Hello viewers, welcome to At Newsworthy Publications, a video channel, YouTube video channel in which I, Ben Gray, an amateur journalist, seek to disclose to the general public, to anybody that's interested, evidence of the most egregious and villainous criminal misconduct being conducted by various of the circuit judges here in Bristol and the High Court judges, obviously centred at the Royal Courts of Justice. This video is called Judge Martin Picton Must Fall. Judge Martin Picton is a circuit judge who is based here in Bristol and who tried me for various issues where I was accused of assaulting and threatening a police officer, Mr. Ross Coombs, in an incident on the 8th of April 2010. But there were other matters that were related to that incident that were also canvassed before Judge Picton. These are the matters that I will also canvass for this documentary to prove the extent of blood on the hands of this judge and the extent of villainy and really sadistic criminal misconduct that this judge has engaged in, and as the title suggests, should be removed from office and himself face a criminal trial or certainly prosecution. I remind the viewers, if they're interested, that judges are not above the law. If they do act in a criminal way that amounts to misconduct in public or judicial office, otherwise known as misfeasance, they can, and in my view, should be prosecuted or investigated for those offences and convicted, and when convicted, obviously sent to prison for a very long time. The rulings of common law are in particular R.V. Bembridge and R.V. Llewellyn-Jones. I shall put the citation details on this screen here. And these cases prove that, contrary to what the official judicial website states, judges are not immune from prosecution for their conduct when sitting as judges. They can be prosecuted and have been in the most recent past, as recently as the 1960s, be subject to prosecution for such criminal misconduct. And of course, because I'm campaigning to bring this to the public's attention, the more I am persecuted by the authorities, the more the police act, the judiciary, in particular such judges as the current resident judge, Judge Peter Blair, KC, and many others, they're effectively acting as though the police are their own private militia. And of course the police are mostly involved with the criminal allegations I'm setting out, so they have a combined collective interest in persecuting me and using the position of office and trust to this effect. And needless to say, I have not got the local press, such as Bristol Post and BBC West and so forth, completely connive with the local judges to prevent any information about these matters going before the general public. They are all one big happy club, and as I hope this documentary will prove, that they are conniving in the most wicked and villainous activities that would be straight out of the Stasi in East Europe, or under Stalin, or indeed the Nazis. There are several incidents that I'm about to disclose, and of course, needless to say, they do involve images and reference to very severe violence, and obviously, if you're of a very delicate disposition, you might want to look away at various points. The initial incident in which I became involved involved in particular a police sergeant, Reginald Gilder, and I shall account his involvement and in effectively the cover-up of and the collusion in an armed assault that took place on the 20th of February 2008. Now, this incident occurred at the Tesco's in Eastville. There's a very large Tesco's that many people may be familiar with in Eastville. I think it's called Eastgate, which is the sort of shopping precinct area around the Tesco's. And I was queuing up, having done my some shopping at around 5 p.m. whilst in this queue, I felt a nudge to the back of my legs, quite a sharp pain, gave me quite a shock. And I turned around, and there was a female who I didn't know with a male. The male was not very tall, but very stocky, and the female was a bit larger than him. Indeed, I think she was overweight. Of course, we're talking about many years ago, so my memory isn't that clear about the description. But in any event, I turned around and I gave them a sort of a sharp look. I didn't say anything, and I think the female said sorry. To which I didn't respond. It looked like it had been deliberate because, of course, I was standing right in front of her, and I was initially a reasonable distance from her, and I couldn't quite understand how she could have pushed the trolley into my legs. But I didn't make an issue about it. I didn't call her names. I didn't respond in any way. I just simply turned around to continue my queuing, and this upset her male companion. He began to shout at me and told me that I should have accepted her apology and that I was a effing seal or words to that effect. Again, I simply ignored him. I said, I'm not interested, or something along those lines. And this has just incited him further. And within a few moments, he reached into the trolley that was in front of him, and pulled out a glass container full of nuts and threw it right at my face. I ducked, and the container went whizzing past me and smashed sort of maybe 15, 20 feet from me at a cashier desk, maybe 2 or 3 rows down. And there were children there were elderly people queuing. It narrowly, luckily it didn't actually hit anybody. It exploded near everybody, and glass and debris from the nuts went all over the place. I backed away. I was obviously terrified by this male, but I tried not to show it. I just made it clear that I wasn't going to be terrorized by this man. Said something about he's very brave with a weapon or something like along those lines in an immediate response. And the male reached into the trolley, pulled out a bottle of wine, and began to move towards me, saying he was going to brain me with it. Fortunately, at this point, a very large security guard came over and stood between me and the male in question, and kept the male at bay and ushered him to one side. I called the police at this point and recounted to them just what I've recounted to you, and asked the police to attend. And whilst I was waiting for the police to attend, I was extremely nervous. The male hadn't, as far as I was aware, been properly restrained. And whilst I was waiting for the police to arrive, a man called Mr. Kapnos, I'm not sure if I know his first name, but he was the manager present at the scene at the time, and he ordered everybody, all his staff, the junior staff, to sweep up the debris, and therefore was clearly perverting public justice by concealing the commission of an offence. So again, the citation will come up on the screen here, in order to later state that the missile thrown was not glass, but in fact plastic, as though that made a huge amount of difference to the general assault, armed assault that had taken place. And the debris was swept up. I was absolutely terrified more by the act of Kapnos to effectively collude and cover up the armed assault than I was from the assault itself. Indeed, the offence of throwing a missile was obviously possession of an offensive weapon, which carries up to 4 years in prison, and then there was the attempted GBH, which clearly would have been caused if the missile had made contact. But the obviously perverting justice carries up to life. So the perverting justice, the concealing of the commission of the offence by clearing up the debris, was in fact far more serious than the actual assault itself. I said that to the security guard who was still present, I was just going to go outside and get some fresh air and come back in a few minutes to calm down. I was shaking by this point. Again, more from the approach of Mr. Kapnos and his colleagues than I was about the assault itself. When I returned a few minutes later, I've been told that the police had been and gone. There was a PC beer, and I'll see if I can get her first name in due course. But the PC beer and her colleagues had turned up. They hadn't seized any footage. The male who had thrown the missile had been allowed to abscond, to escape, before apparently the police even turned up. No name was allegedly taken by the anybody, by either the security staff who let the male go, or certainly by the police, because he'd already gone by the time the police got there. The police did not seize the CCTV. So, because when I attended the incident, everything had been, the police had already gone, the debris had been swept up, and the male, I was led to understand, had been allowed to escape. I had no choice but to attend the police station the following morning or afternoon to register to give a formal witness statement so that the matter could be properly investigated and CCTV seized, etc. And I should point out that the police station was called New Bridewell Police Station, which very confusingly is opposite what is now called the Bridewell Police Station. So this was in fact the old Bridewell Police Station, which was called the New Bridewell Police Station, whereas the actual police station that now exists is called Bridewell Police Station. So for the purposes of clarity, I was attending New Bridewell Police Station, which, as I say, is in fact the old Bridewell Police Station. And this is much smaller than the new one. The reception area was itself quite small, and the layout is, as we shall see there, I'll show you a photograph. There's a room, there's one door, as you come through the main entrance, there's the reception opposite you, reception desk, which is screened off. To the right of that, immediately to the right of that, is a door leading to the main police station, and then further to the right, is a little room where there's a sort of called an interview room where people can come and give statements and talk to the police in confidence. And so on the 21st of February 2008, I attended this reception area to, as I say, give a witness statement. It seemed very straightforward. There was no dispute from the staff at Tesco's that this violent armed incident had occurred, and I thought it was just simply a matter of making a witness statement, and so this man could be apprehended. He was clearly dangerous. That he clearly committed a very serious violent offence that, as I say, didn't just endanger me, but children and other innocent parties present at Tesco. But unfortunately, with the local police, as is the entire point of these documentaries, nothing is straightforward. Especially if you have had previous dealings with the police, and indeed only a year before, in July 2007, it was admitted that I had been falsely imprisoned and assaulted by the police in another incident in Marlborough Street, which was only a stone's throw from New Bridewell Police Station. So I was obviously concerned about the general approach to the police with me on this matter, but I would have thought that whatever their feelings about me personally, it would be trumped by the concern for the fact that there was this armed assailant at large who had could have quite easily maimed or blinded or done some serious injury to a child or other innocent bystanders. And I was initially dealt with a PC, Damien Hamilton Smith, of which much more later. But Damien Hamilton Smith was initially reasonably polite. We sat down at a desk in the interview room, as I say, to the right on the picture that you've seen. And I was about to give my statement, and there was some issue that I can't remember exactly how it unfolded, but it involved having the attendance of PC Reginald Gilder. Police Sergeant Reginald Gilder, PS Sergeant Gilder, who became involved in the whole witness statement process, and in fact said that he got in touch, as I was later to find out, with PC Beer, who was the attending officer at Tesco's the day before, and said Beer had said that it was all my fault, that I was the instigator, and that I was making false allegations in respect to the incident, and Gilder made it clear in very frightening terms, that he was going to use violence against me, i.e. he was going to arrest me in some way for perverting justice or wasting police time in terms of making false allegations in respect to the incident. And as I didn't have a recording device, I wasn't as familiar with the law as I am now. I heeded his warnings and left the police station, unable to give the witness statement that I had initially intended to give. In due course, I couldn't get legal representation. That's another ongoing issue that forms the basis of all my documentaries. So I raised the matter with Professional Standards Department. I made very serious allegations about perverting justice against both the officers at the scene. I didn't know who their names were, I don't think, at the time. And against Gilder, accusing them of perverting public justice, misconduct in public office. I may not have used those exact terminologies because, again, my knowledge of the law wasn't that clear. But generally colluding in the armed assault incident the day before. And as I say, the armed assault was just the tip of the iceberg, because there was, of course, the collusion by Katnos and others in sweeping up the debris and generally cover and allowing the malefactor to escape. This matter was investigated, in quotation marks. I use the word in the most sarcastic sense, because it wasn't investigated at all, by an Inspector N. Power. I don't even know what his first name was, because that wasn't included in the report. The report reference was CO 200-08. I will now read out what the statement, what Inspector Power's findings were. To begin with, officers subject of complaint. He stated here that simply the only officer relevant was Sergeant 2969 Reg Gilder, based at New Bridewell Police Station, Bristol District. Well, that was clearly not the case. I was accusing not only Gilder, but the other officers involved who had attended the day before of colluding in the cover-up of the armed assault. And the report goes on to state, on the afternoon of Wednesday, the 20th of February 2008, the complainant became involved in a confrontation with another customer at Tesco Superstore in Eastville, Bristol. The police attended at the premises in response to a call from the complainant. However, he had left the building by the time the officers arrived at the scene. The next afternoon, Gray attended at New Bridewell Police Station, intent upon reporting the incident as an assault. He spoke with PC 1043 Hamilton Smith in the first instance, and subsequently with Sergeant Gilder. No crime report was completed in respect of the incident at that time. Allegations. Gray's allegation is contained in a letter addressed to the Chief Constable dated the 22nd of February 2008. It is one of 3 separate allegations contained in the letter, which also indicates an intention to pursue civil legal action against the constabulary. Consequently, the Legal Services Department has been supplied with copies of the relevant material. Gray is a frequent complainant and litigant against the constabulary. Gray describes an incident in a Tesco supermarket that began with a female customer pushing a shopping trolley into his legs. Gray states he verbally protested to her and was then subject of an assault by an unnamed male who was obviously associated with the woman. The alleged assault consisted of the male throwing a glass jar at his head, which missed but broke on impact with the floor. The same male then allegedly threatened Gray with a wine bottle. Store staff intervened in the situation, albeit Gray states that they attempted to prevent him from contacting the police on his mobile telephone. Gray states, I decided to go for a walk to calm down. As a result, he missed speaking with the police officers that arrived at the scene in response to his earlier call. As a result of the following afternoon, he attended at New Bridewell Police Station, intent upon reporting the alleged assault. At that point, a sergeant spoke to him and accused him of acting aggressively at the store and making false allegations. The sergeant refused to deal with the assault allegation. The relevant police incident log confirms that Gray contacted the police from Tesco store at 17:17 hours on 20th of February 2008. A police unit consisting of PCs, Beer and Cohen arrived at the store at 17:40 hours to find that Gray had left the premises. I have listened to the recording of Gray's telephone call to the communications centre and prepared a transcript of the relevant conversation. The call clearly reveals Gray to be in an excitable state. That's likely to be the case if I've just had a missile thrown at my head and then threatened with a bottle of wine, and then had to witness the debris, the evidence of the crime being immediately concealed by the Tesco manager. The recording completely contradicts the assertions made by Gray at paragraph 1.4 of his letter of complaint. The operator, who in my opinion dealt with call in a calm and professional manner, requested Gray's address details once. He gave 6 Boswell Street, but then started to argue about how he could not give his details for fear of reprisals from his alleged assailant. Gray was requested to provide a description of his assailant, but he refused to do so. In the telephone call, he describes how his assailant had been escorted away from the scene. However, in his letter of complaint, he states that the assailant was standing within feet of him whilst he was making the telephone call. Well, on that point, that is clearly it is Inspector Power who's lying his head off, because of course, if the assailant had been escorted away, it was obvious that he was in front of me at the time to be led away. It is Power's position that makes no logical sense. How could I be misled? How could he have been led away if he wasn't already in front of me? I mean, it's as glaringly obvious as that. And of course, initially, because he was in front of me, that is why I didn't want to give my personal details in front of him. And of course, I was also concerned about the fact that the debris was being cleared up, and then of course there was some malice on the part of Kapnos and the other staff there who were busily perverting justice, whilst this man, the assailant, was being led away. The operator picked up on this discrepancy in Gray's account at the time of the call, but it was terminated at Gray's end of the line before this could be resolved. Well, how could the operator be picking up on the discrepancy if the discrepancy is, according to Power himself, between what I said in my letter and what I said in the call? If the discrepancy had occurred within the call, then why didn't Power say so? Why is he relying on the letter, which obviously the operator couldn't have known about because I hadn't written the letter yet, let alone sent it to the police? The operator picked up PC Beer, who was the attending officer at the scene, confirms that Gray was not present at the store at the time of her arrival. She spoke with store staff who informed her that Gray had overreacted to an incident in a queue, shouting at a woman. The woman's partner then threw a plastic tub of peanuts at Gray. PC Beer states that store staff queried the possibility that Gray had mental health issues, as his behaviour and demeanour were completely unreasonable. He was apparently aggressive towards staff. Her pocket notebook entry made contemporaneously supports this account of events. Well, I mean, what can I say to that? Obviously, the staff are going to discredit me because they're the ones who PC Beer is colluding in with concealing the commission of an offence. As we're about to find out, not only was the debris swept up, but the CCTV was not seized, so that obviously they could say anything they like about me because all the recording was not made available for reasons never explained by Power. Obviously, I'm going to be in a slightly aggressive state if not only have I been attacked by this male, which obviously makes me self-defensive anyway, and of course I would have been well within my rights to use violence against him to defend myself, because if he's already attacked me once and he's coming towards me with a bottle and being allowed to do so by the staff, then obviously I could have used reasonable force to prevent that. Obviously, how that equates to mental health issues, I would have thought I would have mental health issues if I had simply stood passively and quietly while this man was assaulting me with weapons. And of course, the mental health issue seems to be far more to do with the man with the weapon than it could possibly be towards myself. In response to the receipt of Gray's letter of complaint, an officer attended the Tesco store on the 4th of March in an effort to preserve any relevant CCTV evidence. So at 4th of March, we're talking about more than 2 weeks after the initial incident, 30 days after April, June. So yes, it's a day longer than a fortnight, which of course gives the staff plenty of time to overwrite the CCTV or disappear it, and it probably is automatically overwritten after a certain period anyway. And no explanation is provided by Power as to why Beer did not immediately seize the footage or ask about it. Didn't he? I mean, if it was being sought on the 4th of March, it's therefore being openly admitted that the footage was not even sought after by Beer to confirm whether or not to confirm what had happened, and the extent to which, for instance, the container was glass or plastic, and what I was doing prior to the container being thrown, where it landed, did it land near children, and so forth. All of which should have been immediately obtained when the officers attended. And even if I didn't want to give evidence, even if I had withdrawn from the proceedings entirely, clearly there was evidence of a crime that could have been dealt with in its own right, because you've got CCTV of an armed attack, and that's really all you need. And then you've got the perverting justice in terms of the cover-up from Kapnos and gang. So they talk about preserving any relevant CCTV. Well, it's seizing footage that the officer is supposed to be involved in. Store staff advised him that no CCTV recording of the incident existed. A member of the store staff, Mr. Caswell, did provide a statement that he had written on the day of the incident, prompted by the nature of Gray's conduct whilst in the store. He states that there was no broken glass near the scene of the confrontation between Gray and the other male. He saw an empty plastic tub on the floor and a lot of peanuts scattered around. This confirms the account given to PC Beer. Well, that's complete fabrication, because the debris had been swept up. Even if they accept that there was a broken container of any description, then that should have been seized as an offensive weapon, which had been used by the unknown assailant. So it's obviously corrupt and perverting justice, whichever way you come at it. Either the debris had been swept up, that was clearly perverting justice, or the debris remained on the floor, and of course I saw them sweep it up, but of course they haven't seized the CCTV either, so we can't know what, so there's no evidence as to what actually happened. Was it swept up, or was the debris still there when the officers arrived? And then if it was still there, why didn't the officers keep the debris as evidence of the weapon that had been used to attack not just me but any other members of the Tesco building? A store manager, Mr. Kapnos, has also supplied a statement regarding this incident. He states that Gray appeared to be very agitated and aggressive, and on several occasions tried to come over to the other male and continued the confrontation, all of which is utter fabrication. I would have been entitled to go over to him to restrain him, not only to protect myself or indeed endanger myself, but to protect other members of the public, because this man is still coming at me with a bottle of wine. There's no confirmation as to, there's confirmation about the initial assault, but it was plastic, so it didn't really matter. That is the officer's, that is Power's position. But of course, what about the coming at me with the full bottle of wine, which of course definitely was glass and would have done considerable damage to me, and I'm not supposed to react to that. I'm not, indeed, my even responding to it, as anybody would with an armed attack, with being angry, is evidence that it's me that is at fault and not the armed assailant. He describes the other parties, this is again Kapnos, he describes the other parties to the dispute as being concerned regarding Gray's behaviour, such that Mr. Kapnos accompanied them out to their vehicle to prevent any further incident. So he says that he allowed them to go out of concern for their safety, and not mine, having at least attacked me with one weapon, if not two. No description of what I'm doing other than allegedly approaching them is given for them to be. And why would they have to leave the entire building or leave the premises in a car? They could. There's no suggestion that I pursued him. It's not as if the security guards and staff all over the place. It's not as if there's any suggestion that I've actually tried to get to another part of Tesco's to apprehend him or restrain him, as I would have been entitled to do anyway, especially given the staff. It didn't occur to me that they were actually going to let him go entirely from the scene. Mr. Kapnos confirms that there was no broken glass at the checkout, only peanuts on the floor. Well, it was Kapnos that was the manager that I say allowed ordered his colleagues to sweep up the debris in the first place. He states that Tesco do not sell peanuts in glass jars. The incident evidence of Messrs. Caswell and Kapnos substantially contradicts the claims made by the complainant in this case. Well, of course, they've perverted justice, because they're the ones who allowed this male to escape. They're the ones who won't ask for CCTV. Because CCTV wasn't taken at the time, and because it was left until the beginning of March before it was even asked about, obviously they can say anything they like about my conduct and blame me, even though the only facts that aren't in dispute between myself and the staff was that a missile had been thrown at me and other clients of Tesco. And of course they have a massive vested interest, because they want to, apart from anything else, they want to ensure that they're not held liable for the assault against, because they could have been sued not only by myself, but of course by other members of the other clients, customers of Tesco. He concludes more or less with the following. I have caused Gray's allegation to be recorded as a crime on the Guardian Incident Recording System under reference number 11595708. In accordance with established procedures, I have finalised the crime report in the following terms. I have decided to take no further action in respect of this incident for the following reasons. Credible independent witnesses contradict Gray's account. There is no CCTV evidence to resolve the incident either way. So those two bases, the risk of repetition, are because Beer and Inspector Power have colluded with the Tesco staff in not seizing the CCTV, which was clearly available at the time of the incident, even if it wasn't available in March. So they perverted justice by not seizing the CCTV. They perverted justice by not keeping the debris, even if it was on the floor, which I say it wasn't because it had been swept up by the staff. They haven't confirmed whether or not they do sell peanuts in glass jars. I don't even know if it was peanuts. It looked like peanuts at the time of the incident but it happened in a flash, so I can't be absolutely sure what was in the container. All I can remember is that the container exploded in what was clearly glass, or in a way a glass would explode, and not plastic. So the conclusions about credible evidence, the only reason why any evidence provided by the staff at Tesco is considered credible by Inspector Power is because Inspector Power himself is a lying criminal colluder in all the violent offences, armed assaults carried out by me, but against me by the unknown assailant. The fact that the assailant had escaped, was allowed to escape, etc. This officer is lying about all the material evidence, issues in the evidence that would have proved my version of events beyond merely the confirmation that the assault had taken place in the first place, the armed attack. That is why he's found credible other people's testimony, because it agrees with his own completely corrupt and venal approach to this matter. And again, of course, at the risk of stating the bleeding obvious, his concern should be in regards not simply to the armed assault against me, but of course against the innocent other members of involved in the incident. He states that Gray is known to be aggressive and provocative in his behaviour as a result of numerous previous incidents in which he has been involved. This is reinforced by the evidence of Tony Kapnos describing him as the aggressor in the incident. Well, where is there any evidence to support this vile calumny against my character, as though I'm walking around all the time being aggressive? It is the police who are aggressive, because they're the ones who falsely imprisoned and assaulted me by their own admission only a year before, in 2007. I was also charged with various other matters, which I was acquitted on, having represented myself. So the jury that acquitted me in those matters, which I can't describe because I've got a restraining order preventing me disclosing them. Again, the jury agreed with me and not with the police or the CPS that it was the other person that was the aggressor and not myself. And of course, this officer doesn't know what I'm like in my daily life. And if I'm maybe aggressive in one incident with one particular person in one particular scenario, it doesn't mean that as a general rule I'm aggressive all the time. And what does provocative mean? Even if I was provocative, in quotation marks, it doesn't mean that missiles should be thrown at my head in crowded supermarkets as a consequence of that. So in effect, he's more or less admitting, he's more or less saying that he's saying, well, in fact, we now live in medieval Europe, and people are branded as a certain kind of character that other people may find provocative. Then if people want to throw missiles at them, then we'll collude in those armed attacks and not protect the public, as well as Mr. Gray, as a consequence of that approach. This is reinforced by the evidence of Tony Kapnos describing him as the aggressor in the incident. Well, Kapnos was nowhere near the incident at the time it happened. Of course, Kapnos arrived at the scene after the missile had been thrown to busily clear up all the evidence of the armed attack. He got rid of the debris. He got rid of the actual assailant. They were allowed to depart, which of course then justified no investigation on the basis that Inspector Power gives in respect to him not being present, meaning that matter's going to be NFA'd. Of course, he could have been identified from the CCTV. He's almost certainly, well, if he's going to throw missiles at people's faces on the briefest excuse, he's almost certainly known to the police generally anyway. Anyway, this chaos to me, I wasn't allowed to get. I mean, the irony is that he did, as we shall come to in a moment, find against Reginald Gilder for not taking the witness statement from me. But this inspector, despite opening the matter and investigating it himself, which he shouldn't be doing because he's supposed to be independently investigating the officers involved in Gilder and Beer involved in the cover-up, the alleged cover-up and collusion in the assault. But of course, I didn't give a statement anyway. And if I give a witness statement, then of course I've sworn to it under with severe consequences if there's anything in it that's false. But of course, he doesn't allow that because then, of course, that would have given more credit. It would have made even more outrageous as to why he's finding in the favour of Tony Kapnos, who's already, but by any criteria, committed all manner of offences. He's allowed the man to escape. He's swept up the debris, or why wasn't the debris seized anyway? Beer is certainly colluded in that offence and not seized the CCTV. Or overwritten. No reason is given as to why there's no CCTV was made available when even if the police did attend on the 4th of March to locate it. My inquiries have indicated the Gray's account of this visit to Bridewell Police Station the following day regarding this matter has greater credibility than his account of the original incident. On arrival at the police station, PC 1043 Hamilton Smith initially spoke to Gray. Gray's account prompted the officer to contact PC Beer by radio. As a result of this conversation, he became aware that Gray was likely to have been the instigator of the incident at Tesco and not the victim as he claimed. PC Hamilton Smith realised the potential for a complaint against him at this point and requested the assistance of Sergeant Gilder. The account of the sergeant is contained in his written response of the 29th of July to a Regulation 9 notice served on the 17th of July. The crux of his account is as follows. I spoke to Mr. Gray and I again reiterated to Mr. Gray that based on the information that I had, I did not believe he had been assaulted and in fact he had been the main offender at the store. And only due to the fact that no one wished to pursue the matter, he was not at the stage being arrested for a public order offence. Mr. Gray did not appreciate me telling him this and he became quite agitated. I then went on to inform Mr. Gray that I felt his allegation was in fact a false allegation and that he should be careful because he could be prosecuted for wasting police time. Both PC Hamilton Smith and Sergeant Gilder evidently found Gray to be an awkward individual with whom to have to deal. Unfortunately, no explanation is to given why I've been made an awkward individual. All I've done, according even to Power himself, is turn up to give a witness statement when there's no dispute that a missile was thrown at me, whether it was plastic or glass. But I'm awkward for just as well as being provocative and aggressive. The Constabulary Police Policy document on the recording of crime 52 QP 106308 sets out the requirement to take details of a crime report, even in cases where officers perceive the allegation to be false. The relevant guidance states, remember the approach is always to record a crime in the first place, and if the investigation later produces verifiable information that this did not occur, the crime can be legitimately recorded as no crime. This is what should have happened in these circumstances. The witness evidence of the Tesco store staff and the absence of CCTV material would have led to the allegation being no crime and no further action being taken. The failure to complete a crime report in respect of the allegation made by Gray as required by constabulary policy means that this complaint must be upheld. I have no doubt that had the case been recorded, inquiries at the Tesco store would have resulted in the case being recorded as no crime. Gray's account is not reliable. Store staff describing him as the aggressor at the situation and his claim that he was the target of a glass jar missile is patently false. None of this, however, detracts from the requirement to record the allegation in the first place. Sergeant Gilder must accept responsibility for this omission, and I believe that an appropriate and proportionate response to this oversight on his part is management advice. This complaint should be recorded as substantiated and the complainant be advised accordingly. Sergeant Gilder should receive advice as per paragraph 12 above. So that is the conclusion of Inspector Power. I should add, for what it's worth, that this was upheld by the IPCCC in case reference 2008-019-307. So that viewers, in a nutshell, is everything you need to know about how corrupt and evil the the general Avon and Somerset Constabulary are. Before we come near the judiciary and the judges involved and barristers involved in what they knew about this incident, it just sums up exactly all you need to know about how, if they've got a personal vendetta or a personal issue with the complainant, if that complainant in particular is weak, it's more than anything else, it's about strength and power. No pun on Inspector Power's name, even if that is his real name, because of course we can't identify him. There's nothing online where you can locate a Power, an Inspector Power, an Inspector N Power. If you Google it, you can find quite a lot of officers online, but not this one. And of course, he doesn't give his full name, so he's effectively anonymous. Somebody who's made a complaint is supposed to be dealt with personally. They're supposed to communicate with you and take a statement from you. And the irony is that he chastises, mildly Gilder for not taking a statement from me, but he never took a statement from me himself when he then carried out the investigation, which he shouldn't be doing anyway. But all he does is he finds in favour of the staff. So the staff have the power. They're the ones who can have access to, if they do get litigated, to big shot lawyers and barristers. And I'm known to the police having been a complainant in other matters. The word complainant comes up all the time, as you shall see throughout this documentary. And they find in the favour of Kapnos in particular, who has perverted justice hand over fist, even by on the terms that Inspector Power relates. So there we can see how from this report and from the police approach to the incident, the armed assault that occurred in February 2008, you can understand how all my life is going to be involving any issues of authority or the police going forward. This is particularly so because I was on benefits at the time and was claiming, in order to claim benefits, I had to attend a job centre, and in order to attend the job centre, I had to go through various security staff or deal with security staff who, of course, by now heard about my reputation, in quotation marks, as being provocative and aggressive, as set out by the clearly ridiculously biased Inspector Power. And of course, security staff in these vicinities, many of whom have criminal convictions of their own, some of which are even unspent, so they're still subject to live to probation conditions, or certainly to the fact that they are still known to be violent offenders and have these convictions. One thing led to another, certainly with my local security staff, and I've been subject to multiple arrests in respect to incidents involving them. I therefore had to sign on at Bedminster Job Centre and got involved with the incidents with them. And I'm not going to obviously go into the details of that in this documentary, because it would detract away from the main issues which I'm trying to focus on in terms of Judge Martin Picton. But suffice to say, I was prosecuted and successfully prosecuted in regards to an incident that occurred on the 13th of August 2009 at the Bedminster Job Centre, and I was charged with ×2 common assault against security staff there. I think Mr. Povey and a Mr. Ryan were the complainants in that matter. And I was found guilty by District Judge Philip Gillibrand on the 19th of February 2010 and sentenced to a suspended sentence of 16 weeks, I think it was, for that matter. And that incident was based on clear-cut perjury from these officers and from the security staff and the police officers involved in the investigation, including sort of pretending that the guy had a black eye when there were witnesses to say, even from the job centre itself, saying that there was no black eye, that there was a medical record from the nurse who examined, I think it was Ryan, who said that there was not a mark on him, hours after he had claimed to, other witnesses had claimed to see a black eye on him, and then he had a black eye that suddenly appeared when photographs were taken by PC Earl da Costa sometime later. And that's just one example of the just endless plethora of perjured and outrageous perverting justice, perjury and perverting justice had occurred as a result of that prosecution. Of course, I can't get legal representation, and that is was another reason for my conviction. And I was so incensed and upset and outraged by the conviction that I did a sort of a peaceful protest at the court after the proceedings were over, which included my being lying down on the floor in a sort of, as I say, in sort of passive resistance to the matter. Having been tried without representation, without a jury, is whether or not you're guilty is one of the most is in and of itself a punishment, regardless of whether you end up going to prison or fined or whatever as a result of it. But let alone on the basis that I refer to here, and I refer you to the Inspector Power report of the incident in February 2008 as a sort of a benchmark approach that the police take with me in all matters. And as a consequence of this lying down on the floor, I'll show you the images from the CCTV that was later taken of the manner in which the two security guards, one called Gavin Manley, who's the smaller person you see in the photograph, and the much larger gentleman is called a larger security guard. I only know to be called Mr. Chapman. I don't know his first name. I never received it. But they thought it was well within their rights to remove me or attempt to remove me from the position that I was in the court. I think it was floor 1 or floor 2 of the level 1 or level 2, by pulling my arms up behind my head as I'm lying down, so the full weight of my body is pushed against my shoulders and therefore creates extraordinary pain and potentially is going to dislocate my shoulders dislocate my arms from the shoulder sockets. That to me seemed completely unreasonable force. That they can use force, I don't dispute that, under Section 53 of the Courts Act 2003. Security staff do have powers to remove individuals who are being disruptive in the court building. Obviously, I wasn't being disruptive because there were no proceedings. I wasn't in a courtroom. I find it very difficult to see on what basis I was disrupting any proceedings, because I was simply lying passively on the floor. I wasn't threatening, I wasn't shouting, anything of that description. But I, for the sake of argument, I'm happy to accept that they did have the power to remove me from lying on the floor. If nothing else, I suppose I'm a trip hazard. But the force, as the Act clearly makes, as clearly states, is the force has to be reasonable in the circumstances, and there were plenty of security guards around. They could have dragged me. They could have dragged me to another part of the building or out of the building, which is of course the main objective of removal of disruptive individuals in court buildings. Not removing my arms from my sockets. I clearly wasn't an immediate threat. If I'm lying face down on the floor, I'm the definition of not being a threat to anybody in that position. And I complained to the police and that I'd been assaulted by these guards and that they should be investigated on that basis. And in due course, I received a letter, which I'll read out now, albeit I didn't receive it until sometime after the main incident that deals with the ended me before Judge Martin Picton. And the conclusion was given to me by a PC David Townsend to 2593, and he provided this report on the 9th of August 2010, which, as I say, was some months after the incident. Another incident involved Reginald Gilder, which I'm about to come to. But the general conclusion, which I won't read out the whole letter, but the general conclusion of David Townsend was that I have reviewed the CCTV at the location that covered both the incidents that you referred to and have spoken to the security officer you have complained about. That was Mr. Chapman, I'm assuming. I also have spoken to a second officer identified from the CCTV. Well, he means a security guard, because security guards are not officers, as far as I understand it. I have liaised directly with the detective sergeant that oversees all investigations in my department also. It is our conclusion that security staff have acted within their powers and using reasonable force as required at handling the incidents in question. I will explain further how and why we came to this decision. I understand you have concerns over the way the courts have dealt with the matters on the day, but when you refused to leave the courtroom, the district judge present ordered you to leave. This gave the security personnel present the legal right to use reasonable force to remove you from the courtroom. By all accounts, this seems to have occurred. Once outside of the court, you have got up from the floor and made your way to a water fountain and appeared to have a drink. You are shadowed by the security guard in question while you do this. It is then that it has been reported to us that you made comments about returning to the court, and this was not going to be allowed by the security officers present. They are still within their powers to refrain from allowing you to re-enter the courtroom and to use reasonable force if required. To this point, that you have gone to the floor of your own action and lay out on the floor. The security officers present felt they had no option but to restrain you, so as there were no more chances of your returning. There is spelt wrong, but let's not quibble. There were no more chances of your returning to the court. They also felt that they had to remove you from the building itself, as you were going to continually try and return, and this would cause further disruption to the courts. Due to what was occurring at the time with yourself, the entire court building was in lockdown until the police arrived to deal with you. The two security staff officers restrained you in techniques they had been trained in as part of their licensing, and they attempted to aid you to standing up. You have remained a dead weight, so the officers had no option but to put you back down, to which the police arrived and then have dealt with you. Well, I don't understand how I could be being restrained. If I'm on the floor and I'm not creating any disturbance other than being on the floor, A, I don't need to be restrained, and B, lifting me to my feet is not restraining somebody. Restraining somebody is when you keep them in a single place, or certainly restrain them from being able to move themselves. They're doing nothing of the sort. They're trying to get me to move, which is clearly the opposite of restraining somebody. But how could it be reasonable to cause them such immense pain and potentially, even if they're being obnoxious or difficult, which I totally accept I was being difficult, not necessarily obnoxious, but on what basis could having potentially ripping their arms out of their sockets be reasonable force? And they don't simply just try and lift me, and as soon as they can't actually lift me off the floor, or can't do that without obviously causing some major injury, put me back down. They can clearly be seen holding me for some time and raising me so that I'm 2 or 3 feet from the ground, and therefore the full weight of my body is being pushed against my shoulders. You can decide for yourself whether that was reasonable force, and of course it's impossible for you to really judge about my state of mind unless you know about the case that was before Philip Gillibrand, Gillibrand. So as I say, that will be for another documentary at another time. So all we do know, however, and the important fact for the purposes of what I'm about to disclose next, is that this was an official investigation in terms of an official allegation of assault. It wasn't based on thin air. There was CCTV footage of something clearly approximating violence, in my direction, or unreasonable force, and therefore amounting to assault. And there was a Guardian record of 5882910. And so the issue there, that's for the purposes of this documentary, is that I had to attend court on the 8th of April 2010 in respect to another matter, and unfortunately I can't remember exactly what it was, what it involved, but I had been summoned to the court, to the Bristol Magistrates Court, and therefore I had to attend. The issue was that I felt that I shouldn't have to attend at all because of the ongoing criminal investigation, and the matter should have been transferred to another court venue. But because that hadn't been facilitated, it's clear that I should have had police present so that I wasn't intimidated or being in any way at risk of further assault from, in particular, Mr. Chapman, because he's the manager, I should have mentioned, at the court building. And he was there. I tried to get to the hearing on the 8th of April and seen Mr. Chapman blocking a doorway that I had to get to in order to get to the hearing, and contacted the police and said, could the police attend so that I can get to this hearing? And indeed, I would assume that there were police even present potentially at the court venue, so that there would be no any interaction between myself and Mr. Chapman. And of course, if there was another incident with potentially with somebody else or whatever, I could not rely on security if the manager of the security was himself under criminal investigation at the time by PC David Townsend for assaulting me in terms of the incident in February of that year. So I contacted the police several times over this issue. It was just a simple matter of having any police that were already present at the court building just to make sure that I could get in and out. They've got the body-worn video cameras and the CCTV cameras, so that I was secure about going to the court hearing, having to run the gauntlet of Mr. Chapman. And the police simply refused to assist. And I attended New Burwell Police Station again. Apparently, according to statements that I'm about to read out, I dealt with, at some point, I actually dealt with Reginald Gilder on the first visit, which was, I think, in the morning, and I did lie down on the floor, I think, as they state in their statement. So again, I engaged in this peaceful protest kind of approach. And I was insistent that I wasn't safe, that it wasn't right that I should have to go to the court while this man was still under criminal investigation for the alleged assault in February. And I don't recall, obviously, because I'd only dealt in the most heated and brief terms with Reginald Gilder when I made the complaint about him in respect to his conduct in 2008. I didn't remember him until I didn't know I was dealing with him until after I eventually got arrested, involving himself and several of his colleagues later the day on the 8th of April. But apparently he was involved, other officers were involved, and they were claiming, as we shall see from the statement in a moment, that I was demanding an escort to the court, which I was not doing. This was complete fabrication. I was simply asking for officers to be present when I came in and out of the hearing. The hearing itself was only going to be for 15 or 20 minutes, so that there was no altercation or interaction with Mr. Chapman. What I shall do now is read out the witness statements from these officers in turn. And the first officer I should deal with is Tina Brewer, and she's not actually an officer, she's a civilian who's a receptionist on the front desk. I'm fairly sure she was involved in the 2008 incident with myself and Mr. Gilder, where Gilder made no uncertain terms he was going to threaten me to arrest me if I didn't leave when I wanted to report the incident at Tesco. So in a moment I'll read out the witness statements regarding this incident, but the footage, it's important to look at the footage first so that we have some context. The footage is of my second visit that day. Apparently I've lied down on the floor. I've been assured, I'm fairly sure I was assured that the police would be attending the court to ensure that I could get to and from the hearing. And they never turned up. I attended about 3 o'clock again to protest the fact that there was no police officers present to ensure that I didn't have to engage with the subject of the criminal investigation, Mr. Chapman. I turned up about 3 o'clock, and I'll show you the footage now, and then we'll come back to the witness statements that explain why I was arrested, or don't explain, but certainly go into their account of events leading up to and including my arrest on the date. So there you see what has unfolded. Obviously, you don't have any sound recording, so you have to go basically on physical movements of myself and the officers. And of course, the first thing I'll point out, which is hopefully quite obvious anyway, is that obviously I wasn't aware that the only CCTV camera was pointing down, or the only one that I was provided with was pointing down at the seat, at the bench where I'm seated. And clearly, what the officers have done, the two officers that you see initially are PC Karen Stenner, the female officer on the left, and PC Ross Coombs, who's the male officer on the right. And what they've done is they've obviously covered me, concealed my existence at all from the angle of the CCTV camera. So this then gives them the opportunity to say anything they like about my body language and what I'm doing, whilst they're not only protecting the line of view from the CCTV camera, but obviously intimidating me and presenting me with their groins as the main focus of my attention when I'm supposed to be engaging with them. And of course, as we'll come to, Reginald Gilder was effectively instigating all of this incident. I wasn't aware of this at the time, obviously. And of course, he's been involved in the cover-up and the collusion surrounding the Inspector Powers 2008 report as to events at Tesco. So he, apart from anything else, he's aware that the police regard me very much as is now become established fact that I'm, although it's completely untrue, I'm aggressive and provocative. So clearly, if this is what they view me as, and potentially volatile is another word that they like to use a lot, then of course they should be treating me accordingly and not coming straight, presenting me with their groins and looming over me in order to be as intimidatory and themselves as provocative as possible. But anyway, we'll look at the statements, and I'll read out the statements, and then obviously we'll analyse the extent of fabrication and perverting justice and so forth that then unfolds. So Tina Brewer is the first to give a witness statement. She gives her statement on the day of the incident. Tina Brewer is in fact a civilian. She's not an official police officer, and as I say, she was almost certainly involved in the incident between myself and Gilder on the 21st of February 2008. Miss Brewer states, I am a serving police staff member within the Avon and Somerset Constabulary, and my ID number is 7272. I am currently based at New Bridewell Police Station in the centre of Bristol and have worked at the station for 6 years. My role is to deal with members of the public who come to the police station for various inquiries and act as the first point of contact for the members of the public. The front office is based on Rupert Street, and entrance to the front office for the public is via a set of electronic doors on Rupert Street. Well, I'll skip over this bit. She then talks about the first incident, which isn't particularly relevant because there's no dispute. I do turn up. I am complaining about having an officer. Not complaining, requesting to have an officer present because of the issue with Chapman. And I do lie down on the floor momentarily as a sort of protest. And I say, although they don't say that I was assured that an officer would be present if I went back to the court. So we'll skip all the boring stuff about my first visit and get straight to the nub of things, which is dealing with the incident that you see on the footage. At around 15:06 hours, I was behind the EO desk when PC 1043 Hamilton Smith came down and told me that Gray was on his way back to the police station. Gray had rung 999 to say he was angry and was coming back to the police station. I heard the comms operator say that he'd been abusive to the call taker. At around 15:08 hours, Gray walked back to the front office. He was extremely agitated. He approached me and said, "I'm sitting here and I want to see a police officer." I asked him which police officer, to which he replied, "Any, I don't care." I then went to find a police officer, and as I did, PC 3700 Coombs and PC 2348 Stenner came down and went to the public office and spoke to Gray. He was still at the bench. PC 3700, I'll refer to names and not numbers because obviously that Miss Brewer is deliberately trying to obfuscate and intimidate by just referring to human police officers as effectively unaccountable anonymous numbers. So she's talking about Coombs here. So she says PC Coombs approached him and tried to speak to Gray, but Gray became aggressive almost instantly towards him. I couldn't make out what was being said, but I could hear Gray's raised and aggressive voice. I was watching this on the CCTV monitor that is in my front office. The front office is covered by CCTV cameras, which is digitally recorded and stored on a hard drive. There are 2 cameras that cover the public area of the front office. PC 1043 is in fact Hamilton Smith, Damien Hamilton Smith, who of course is the officer that was involved in the complaint in regards to the Tesco incident in 2008. Then went into the customer area as Gray was becoming more and more aggressive. He was shouting loudly and aggressively at the officers, I'm not leaving, again and again. At this point, Gray stood up and put his hands behind his back and shouted, arrest me then, go on, more police brutality, arrest me, I want to go to court. At this point, I saw PC 3700, PC Coombs and PC Hamilton Smith applying the speed cuffs to Gray's wrist behind his back. I took this to be him being arrested. At this point, I was behind the counter and was watching Gray being led out of the station. PC Coombs was behind Gray and had hold of the cuffs. PS 2969, that's Gilder, was on the right of Gray, and PC Stenner was to Gray's left. I was sat at a distance of around 2 to 3 meters from them and had a very good, clear, unobstructed view of the officers and Gray as they led him out. As I was watching, as Gray got to the front doors, without warning, he swung his right leg back quickly and aggressively like a donkey kick. This kick landed straight on PC Coombs's leg around the shin area. PC Hamilton Smith, PS Gilder and PC Hamilton Smith then took Gray to the floor and restrained him. I then called for assistance on the police radio and several officers came down. When I saw Gray kick out at PC Coombs, I was absolutely shocked. I could not believe what I'd just witnessed. Well, so there's not really much there to go on in terms of why I was being arrested. As we shall see with the other officers, Stenner and Coombs, and Gilder, I think certainly Stenner and Coombs both accused me of calling PC Stenner a fucking ugly bitch or an ugly bitch. I can't remember who actually uses the swear words or claims I use the swear words. And I think Hamilton Smith says something along the same lines. But there's Miss Brewer, who's obviously, sorry to use the pun, but brewed up the whole situation because, of course, she was initially there at the first incident. And she's claimed that she doesn't understand why I'm protesting. She does make some passing reference to the fact that I'm asking to have a police escort or police presence and that there's some ongoing matter involving a security guard there. But she's very vague about what I'm upset about and indeed claims that I'm effectively not making much sense. But certainly that's mainly to do with the first instance, which I haven't gone into. But in terms of the second incident, there's nothing to actually indicate why I've been arrested because I'm not leaving is the worst that I've come out with, so she, in some ways, she gives evidence in my favour. She doesn't describe the fact that what can clearly be seen going on, which is Coombs rather twisting me round with the cuffs when I'm trying to speak to Gilder, who I eventually ascertain is the senior officer present, although as I say, I did not recognise him as the officer who had been given words of advice or formally reprimanded for refusing to take a witness statement in 2008. So obviously it's of no interest to her that I may be falsely imprisoned or why I'm being arrested, we shall, before I go on to the other witness statements, I'll just explain a little bit about the law as it stands in this country in terms of why I was arrested. The police, as we shall see, arrested me to prevent a further breach of the peace. That is, they're accusing me of having carried out a breach of the peace and they're arresting me to prevent a further breach of the peace. Well, the law of breach of the peace in this country is extremely clear. It has been set down by the law lords. It used to be very confusing because it could apply to all kinds of situations. And in the ruling of Laporte v. the Chief Constable of Gloucester, it was ruled many years ago that there had to be violence, had to be an incident of violence or threat of violence. And without violence, there is no breach of the peace that has occurred. And there's no suggestion clearly from Miss Brewer's testimony that I've committed a breach of the peace, because there's nothing remotely coming close to violence of any description to necessitate my arrest. And of course, if I'm going to be arrested, it has to be proportionate again to whatever's occurred. And if I haven't even committed a threat of violence of any description, anything amounting to a breach of the peace, which ordinarily would then lead to a charge of some description, because if there's been violence or threat of violence, it almost inevitably is some form of criminal offence, especially if it's towards police officers or in front or around police officers. So in some senses, she's given evidence in my favour, because she certainly hasn't indicated any violence or threat of violence that would necessitate my being arrested. Indeed, she's not given any indication that I was given an indication of why I was being arrested. Indeed, she had to interpret from the fact that I'm being trussed up and placed in handcuffs as to the fact I'm being arrested. But as a civilian, if nothing else, she should surely be more concerned about why another civilian is being manacled when there's not even being informed that they're being officially arrested, let alone explained the basis for that arrest. And we'll come on to Damien Hamilton Smith's witness statement. And of course, Hamilton Smith has come in a little bit later in my exchanges between myself and Coombs and Stenner. And Hamilton Smith states as following: I am a serving police officer 1043 with the Avon and Somerset Constabulary, and I'm currently stationed at New Bridewell Police Station. On the 8th of April 2010 at 14:37 hours, I was on uniform duty at New Bridewell Police Station. I was doing some paperwork when I heard via my radio a member of staff asking for assistance in the front office. I went down and saw a male I know to be Ben Gray, DOB 1107 1966, lying on the floor on his back. So I don't think it was as late as 14:37, but this is to do with the first incident, so we'll skip over that, and then we'll come on to the second incident. Gray eventually left the building, and I carried on with my paperwork. I was sat upstairs at the police station when I heard again over my radio that Gray was coming back down to the police station to cause trouble. I went down and alerted the front office staff of this. A few minutes later, at around 15:08 hours, Gray came into the front office demanding to speak to another police officer. He was in an agitated state and was being very unreasonable. I have dealt with Gray on previous occasions, i.e. the incident when his senior colleague was given words of advice, on previous occasions, and I'm very aware that he is always making complaints against police officers, and so I was not prepared to go and speak to him without colleagues present. At this point, PC Coombs and PC Stenner came down and went into the public area of the front office and began speaking to Gray. I went into the public area and stood away from them. He was sat on the bench to the right of the front door with his arms folded and was displaying aggressive body language to the officers. As PC Coombs politely asked Gray what was wrong, Gray became very aggressive, and called PC Stenner a fucking goon, and accused PC Coombs a fucking goon, and accused PC Coombs of being corrupt, and said he was perverting the course of justice, which I found to be disturbing, as Gray was shouting this at an officer he had never met before. The doors to the front office were still open, and at any point a member of the public could have walked in. Well, of course, in terms of, there's 2 points to make in respect to what Hamilton Smith says there. That first of all, of course, they are perverting justice, because if I'm being prevented because of this ongoing investigation of assault, which entitles me not to go to the courtroom until I'm sure of my safety in terms of Chapman is being investigated for the criminal assault. Indeed, I shouldn't even have had to have been going to that particular court building. But by police allowing that threat to remain in terms of Chapman still being present and a barrier between myself and the court room, then obviously the officers are perverting justice, because they are preventing justice to unfold. They're preventing my attending a court. They're potentially getting me. There's going to be a warrant for my arrest for not attending the hearing. So they're creating a situation whereby I'm being potentially kidnapped or falsely imprisoned on the basis that I'm unable to attend the court building because of the investigation by Chapman, because the police are refusing to intervene while Chapman is being investigated for the assault. And in terms of the anybody coming in and out of the into the room, which is a small reception room at any stage, all the more reason for there not to be any situations of violence, let alone the one that unfolded. And of course, I don't resist the arrest, which I should have done, as I realised on retrospect, because of course it was completely illegal. Because I mean, I should point out that I'm much more familiar with the ruling of Laporte and the legal issues surrounding what is a justified and legal breach of the peace and what is not than I was at the time. So obviously, and obviously the matter was becoming so heated. I've been coming backwards and forwards from the court. I've been so distressed by being blocked off by Chapman and completely have all my attempts to attend the court hearing frustrated by the police. And their approach, and especially Miss Brewer initially, who was just pretending that she didn't understand a word of English and was just agitating and provoking the situation to get me as riled up as possible. So clearly, and this is all the police is doing, and you know, so all the more reason if there are going to be public present. But of course, we know what the approach to the public is from the police, from the conduct surrounding Tesco, and when missiles are being thrown at children and other innocent parties, all the police are concerned about, oh, it's Mr. Gray who's the target. Mr. Gray's in legal disputes and a complainant with the police, so we're going to look at him as the enemy, and anybody who gets in the way of that the intended target is simply collateral damage, as they say in when other innocent parties in general conflicts are put in harm's way. So he then Hamilton Smith then refers to PC Stenner, who he says then tried to get Gray to stop shouting, but he turned his aggression towards her, pointing at her and saying loudly and aggressively, "You fucking ugly bitch, it's the same old corrupt officers as always," which I completely deny saying. Why would I be calling her a fucking ugly bitch? She's not, apart from anything else, she's not noticeably ugly, and it wouldn't do me any good to start effing and blinding in respect to what they're doing. That would be playing into their hands, and it was never said. I found this comment to be very offensive and aimed directly at PC 2348. I found this comment to be very offensive and aimed directly at PC Stenner. I then saw Gray beginning to rise from his seat, which concerned me as he was becoming aggressive very quickly and seemed to take an instant dislike to PC, Stenner and Gilder. Well, I mean, what am I supposed to do? Just remain seated while I argue with their groins? I mean, I'm presumably allowed to rise to my feet. The fact of somebody rising to their feet is not in and of itself surely evidence that somebody's going to attack somebody or being aggressive. Gray is a tall male, around 6'3". I'm about 6'1" and a bit, in truth, but he says 6'3" tall and of stocky build. His demeanour and language was causing me some concern, as it was suggestive of him being very aggressive towards the officers. Gray was now shouting at the top of his voice at the officers, I'm not leaving, put me on CCTV, I want to court, fucking arrest me, I'm not leaving." I'm assuming I want to go to court or something like that. I mean, I want to court obviously has a whole different meaning, but and with that he squared up to PS 2969 Gilder, who had joined us by now in the front office. Well, let's pause there and look at the footage, and I'll do it in slow motion so that we can see where Gilder is and whether or not I'm squaring up to him. Now, of course, what squaring up actually means is anybody's guess. I'm assuming that it's when you get right in their face. Whenever I hear the expression squaring up, it's obviously, it sounds a very military term, and you sort of imagine a sergeant, a drill sergeant going into a private space and shouting, blaring into their nose. That's what I understand squaring up to be. It's when you get right into their personal space. But of course, it's so vague as not to actually mean anything directly. So if it's an officer describing some action that, in my case, or in this officer's case, is saying leads to my being arrested, it's too vague to really mean anything. But assuming that's what it means, I'm going nowhere near Gilder. In fact, it's Gilder, as we can clearly see, who's stood far to one side of the incident. He's near the front doors, and then I have to push past PC Coombs, and obviously we'll come to PC Coombs because he's illegally restraining me anyway at the time. He's putting hands on me when he's not purporting to arrest me or intending to arrest me at that time, so that's already a criminal assault. In order to get myself out of being entrapped by Coombs and Stenner, I move around Coombs, and I had to sort of barge past him to get through him. And it's at that point that Gilder, as we can see, moves over to me. He's come a good 4, 5, 6 feet towards me, and at no stage am I going up to square up to Gilder. This is an utter fabrication made presumably at the time, and it's important to point out, as we shall come to, is that another point is that Hamilton Smith became the investigating officer. So he was So basically, my defence was obviously that I didn't, I was being illegally detained, and I was entitled to resist that because in terms of the charge about assaulting Coombs. And that these officers were obviously colluding in the whole business surrounding Chapman, and my having to get to the court building and being prevented from getting to the courtroom because of the police colluding with Chapman in intimidating me from that issue. So he was then appointed to investigate himself for all the counter allegations that I was making. So, of course, apart from anything else, he would have had access to the CCTV that shows his own involvement in the incident, and would have easily proven that I'm not squaring up to Gilder, even if I had approached him, which I didn't even do, but even if I did do that, how does that amount to an arrestable offence of any description? Approaching somebody could be at some point an assault, or it looks like they're about to commit an assault, but it's not. It's certainly not violent. I mean, if he's the senior officer present, as he is, then I'm surely have to approach him to discuss, to complain to him or discuss the issues with him, etc. But this is all largely irrelevant because I didn't square up to him. I didn't go anywhere near him. He approached me. It's the complete opposite of what Hamilton Smith says occurred. So to recap, and with that he squared up to PS 2969 Gilder, who had joined us by now in the front office. When Gray did this, I immediately thought he was going to assault PS Gilder, and so I moved closer to Gray. Gray was continually shouting very loudly and very aggressively, "Fucking arrest me then," and after saying this several times and ignoring the officer's repeated request to calm down and leave, PC Coombs arrested Gray to prevent any further breaches of the peace. Well, there's been no breach of the peace because I haven't been violent or threatened violence. And indeed, the only conduct that comes sort of marginally close to being violent or threatening violence is the squaring up allegation. Presumably, if squaring up is getting into somebody's personal space or getting right into their face, that's obviously a lie because I don't go anywhere near Gilder, as I've already said. And as can be seen, which is more to the point. I then placed speed cuffs on the wrists of Gray in a rear stack position. I checked them for tightness, and after satisfying myself that the cuffs were on in the correct manner, and not causing Gray any pain or discomfort, I double locked the cuffs to prevent any tightening. PC Coombs then began to escort Gray from the building via the public entrance on Rupert Street. Well, he's not escorting me. He's forcibly removing me by the cuffs, as though the cuffs are effectively using the pain of digging the cuffs that were already far too tight. And here's the a photograph of the injuries that were later recorded. These are abrasions that go all the way up from the bottom of my wrist to the top, to way up to the as far as they will go. And obviously we can see that Coombs is a muscly young man. He looks like he's concentrating as though he's writing a difficult essay. The amount of concentration he's putting into twisting me round when I'm trying to speak to Gilder. I am finally now trying to speak with Gilder, as I understand, as the senior officer present, but I'm prevented from doing so. I'm not resisting. I haven't resisted the cuffs being going on as I should have done, as I realise in retrospect. But I've permitted them to put the cuffs on. They put them on too tight, and now Coombs is using them as torture instruments to steer me in the most undignified and degrading and painful way to the front doors. He refers to this as escorting. I picked up the bag that belonged to Gray and was following behind them when all of a sudden I saw Gray raise his right foot off the floor and using a donkey kick, he kicked PC Coombs on his right leg just below his kneecap. I heard the thud of Gray's foot hitting PC Coombs on the shin and saw the officer's legs go backwards due to the force of the kick. Fearing that Gray was going to assault PC Coombs again, I moved towards Gray very quickly and assisted PS Gilder in taking Gray to the floor in a controlled manner in order to restrain him safely to prevent Gray from attacking any more officers. He was restrained on his stomach on the floor, and as we were doing so, he was shouting loudly, "Get the fuck off me, this is police brutality, fucking torture, fucking get off me, I will take this to Crown Court, I'll have all of your fucking bent coppers fucking torture," etc. Well, there's no point in going any further. I accept that I did threaten Coombs that I was going to put a knife through you, gut him like a fish. I don't know what expressions I used, that I was going to shoot him with a crossbow bolt at some point. I threatened him with, all of which I didn't deny doing, but clearly I was entitled to do if I was being tortured and kidnapped by these police officers, which I was doing. And of course, Hamilton Smith was the one who pushed my face, as he brought me down, he pushed my face right into the carpet, and you can see the carpet burns to my face and head as a consequence of the restraints that he used. And then he was appointed, as I say, to investigate himself in terms of the incident that then unfolded. And of course, I couldn't get representation once the custody, because none of the local lawyers will represent me in any matter. And we have the statement of Ross Coombs, also made on the date of the incident. And of course, all of these statements, it should be pointed out that there's a warning or a caveat that comes with the statement, where the signer of the statement has to say, this statement is true to the best of my knowledge and belief, and I make it knowing that if it is tendered in evidence, I should be liable to prosecution if I have willfully stated in it anything which I know to be false or do not believe to be true. Well, we know from the footage that every single witness statement is complete fabrication, but of course, so the prosecution only depends on who the CPS are, who they get to represent them, and who the judge is. But we shall come to that, obviously. I am Police Constable 3700 Ross Coombs of the Avon and Somerset Constabulary, currently based in New Bridewell Police Station, Bristol. At 14:37 hours on the afternoon of Thursday, the 8th of April 2010, I was in full uniform on mobile patrol in company with PC Goulden and assigned to the call sign BW61. At this time, we attended New Bridewell Police Station front office for a report of a violent male in front of the office who was lying down on the floor and refusing to move. Well, this is the first incident. We won't go into we won't go into the detail of that because it's not relevant, particularly to these matters, to this documentary. But of course, a violent male, if I was being violent, I would have been arrested for being violent. And indeed, that is a lawful justification for an arrest under breach of the peace, which is what Coombs eventually arrested me for. But none of the officers have suggested I've actually been violent. They said I've lied down on the floor. And indeed, my only complaint is that I simply needed a police officer at the magistrates for a couple of minutes, and that could have been easily resolved and facilitated. But apparently, according to Coombs, I'm violent, or he's been told I'm violent, which of course immediately means that I am violent, because everything the officer is told about somebody else who's a civilian just becomes fact. That is their mindset. They're unable to distinguish one from the other. They all have to agree on whether the person they're dealing with is whatever one officer says that person is, just like sheep, effectively. So we'll come on to the second incident. At approximately 1500 hours on this day, I was in the report writing room on the first floor of New Bridewell Police Station with PC Stenner when we were tasked to attend the front office as Gray had returned and was threatening to cause problems. As PC Stenner and I entered the front office, I saw Gray sat on the bench with his arms folded. I asked Gray what I could do for him, to which he replied with a torrent of foul abuse at me. Gray shouted at me, calling me a fucking goon, and stated that I was perverting the course of justice by refusing to escort him to Court 8. I never asked for an escort. This is repeated. Obviously, it deals mostly with the first incident, but so I haven't read them all out. But I was not. Why would I want an escort to the court if my issue is at the court? I tried to calm Gray down so that I could speak with him in a more rational manner, but he then saw PC Stenner and began to rise out of his seat. Gray began to point and gesture aggressively at PC Stenner's face and say, "You fucking ugly bitch, it's the same old corrupt officer as always." Well, we can see from the footage, I rise only once. When I rise fully to my feet and I attempt to move past Coombs, and he puts his hands on my chest to prevent me, which, as I've already explained, is an assault. If I'd risen out of my seat to point at her face and shout at her in the way that he's described, it would have been visible on the CCTV camera, and she would have backed off from that, and it would have become even more obvious what I was doing. "You fucking ugly bitch." Gray began to point and gesture aggressively at PC Stenner's face and say, "You fucking ugly bitch, it's the same old corrupt officer as always." But, and of course, I don't need to point out that Brewer didn't hear any of the "fucking ugly bitch," would of course would have been stuck in her memory as the most obvious form of misconduct, and explained why I was being arrested. I told Gray to calm down and to stop being so aggressive towards Stenner, but he continued to shout and swear at me so that I had to speak loudly over him. I said to Gray, "What FO you want us to do for you?" At which point he suddenly jumped to his feet in an aggressive manner. Well, so what's happened? Did I sat back down? Because he said I'd risen to my feet at some point. So I presume he sat back down again. I jumped to his feet in an aggressive manner and pushed past me using his shoulder to do so. Absolute fabrication. Of course, we can see that I've moved to the side of Coombs so that my body is clearly visible, and I'm not able to get past him because he's put his hand on my chest. He lies about not, gives no indication that he's put his hand on my chest. And as we can see from the citation of the ruling of Wood v. DPP, it clearly states that there's been a ruling by the law lords that an officer that restrains or puts hands on a civilian and does not purport or intend at that time to arrest him is committing a criminal assault. So there's no dispute here that it is in clearest terms that Coombs has assaulted me, because he's not arresting me, he's not purporting to arrest me, but he's not only assaulting me by putting his hands on me, he's falsely imprisoning me. He's preventing my leaving, having not formally arrested me before or after at this time. Indeed, his own statement says that he's not intending to arrest me at this time. At the time, and indeed he lies, saying if I had to push past him, he's full, even if what his version taken at its highest is clearly false, because clearly if I try to get past him, I'm having to do that because he's illegally restraining me by his own terms, because he's not arresting me. He hasn't got grounds to arrest me, or he could have arrested me for the Section 5 allegation in terms of calling Stenner a fucking ugly bitch, but he's made it clear that's not his intention. So, and he says, I use my shoulder to get past him. Well, I don't. I mean, I have to use my whole body just to simply push through the fact that he's physically restraining me. I said to Gray, he began to shout, "Put me on CCTV. I want to go to court. Fucking arrest me if you can't deal with me." Gray then began to square up to P.S. Gilder, who had heard the shouting and entered the front office to offer assistance. Gray placed his arms behind his back, but continued to invade P.S. Gilder's personal space in an attempt to push him back. He continued to scream, "Fucking arrest me then." At this time, I arrested Gray and said to him, "I'm arresting you to prevent a further breach of the peace," and cautioned him, to which he made no reply. I was assisted by PC Hamilton Smith, who had also entered the front office after hearing Gray shouting, in safely handcuffing Gray to the back in a rear stack position for officer safety. I ensured that the handcuffs were double locked and that I could fit the end of my finger between Gray's wrist and handcuff. I then began to escort Gray out of the front office exit door on Rupert Street by taking hold of the handcuffs. As I did so, Gray deliberately raised his right leg and kicked it backwards with full force and a powerful motion that impacted with my right leg immediately below my knee. The impact caused my leg to buckle, and P.S. Gilder and P.S. Hamilton Smith had to assist me in safely restraining Gray to the floor. To prevent further injury, I applied limb restraints to Gray's legs to stop him from kicking anyone else. At 15:50 hours, I further arrested Gray and said to him, "I'm further arresting you on suspicion of assaulting a police officer and using violence in a police station," and cautioned him, to which he made no reply. I then requested a van to stop, a van to escort us to custody as Gray began to scream at us, calling us all sorts of fucking goons and telling me, "You fucking wait till I see you out of uniform. I swear to God I will put a knife through you. I will gut you like a fucking fish." These words were said in the public entrance to the front these words were said in the public entrance to the front office and could clearly be heard by the front office staff and members of the public walking past the entrance on Rupert Street. Blah, blah, blah. He then says, I also threatened him later on. During the journey to custody, Gray continued to threaten me, stating, "I will put a fucking crossbow through your neck. As God is my witness, I will fucking throw a brick through your car window when you least expect it." Blah, blah. So that's Gilda's witness statement, and obviously we'll come back to the legal niceties surrounding that in due course. PC Stenner gave a statement apparently made on the same day, and she says that she goes straight to the issue of my second visit to the police station. At around 1500 hours, I was requested to attend Bridewell front office in relation to a male who was being abusive and rude to the inquiry clerks. Upon attending the location, I saw a male who I know to be Benjamin Gray, date of birth 1066, born London. I have had several dealings with this male before, and I know him by face. The latest dealing was on the 19th of February 2010. So she was the officer, one of the officers who knew all about my complaint against Chapman, because she was actually present at the incident when I was peacefully protesting against my conviction at the hands of District Judge Philip Gillibrand. So she would know more than most. It shows the extent of the investigation that was being carried out by David Townsend, that she was never questioned, or presumably wasn't, but she would have had some understanding of what the issue was about, presumably, even if she hadn't been familiar with the actual details of the complaint and the CCTV clearly showing unreasonable force being used by Chapman in removing me from the floor. I spoke to Gray, asking him, "What can I do to help?" Gray was extremely agitated and bright red in the face and sweating profusely on his forehead. He was sat down in the seating area. Gray began shouting, "Where is the corrupt officer who was meeting me at court? The security had already beaten me black and blue, and he had to be held back by security." Gray continued ranting and shouting at the top of his voice. I told him to calm down. "Let's talk about this." I had to talk over Gray's voice as he was continually raising it to prevent Coombs from speaking to him. It appeared to me that Gray had no intention of listening to us and became more aggressive, swaying forwards and backwards. Gray pointed his right hand at me, shaking his index finger at me. He shouted, "You are a ugly bitch, always the same corrupt officer that I see." So no mention of fucking there. You would have thought that if I'd used the F word, she would have put that in her statement. So we've got three different versions now. We've got the version of Brewer where there's no shouting or swearing at all, and of course which agrees with my own version. There was. I think Brewer said I was shouting, but there's no effing and there's no bitch. The word bitch used according to Brewer herself. Then there's Hamilton Smith and Coombs say that I call her a fucking ugly bitch, and she herself says I just simply called her a bitch. So as I say, you take your pick which version you want to believe. Always the same corrupt officers that I see. PC Coombs was trying to calm Gray, asking him, "What do you want us to do for you?" Gray jumped to his feet, shouting, "I want this on CCTV. Put me on the camera. I'll have you in court. I'll have you in court." I would have probably used have. I would have said have if I was going to say the word at all. "Arrest me. I want to go to court. They can't deal with me." I then became aware that P.S. Gilder and Hamilton Smith had come into the front office. They were stood directly behind us. Gray pushed past Coombs. Well, she doesn't mention that Coombs is, again, physically restraining me, physically putting his hands on me, which is an assault in its own right. And confronted P.S. Gilder in an aggressive manner. Well, absolute fabrication. Gilder, I don't go near Gilder until after I'm arrested, and that's only because he's already approached me and he's also put his hands on me in an aggressive manner. Gray was still shouting, "Arrest me." He stood with his arms behind his back. P.C. Coombs arrested Gray and attempted to take hold of him. She doesn't say why he's arrested me, and she doesn't say whether PC Coombs. She seems to admit that PC Coombs hasn't told me while I'm being arrested. I looked away from Gray for a moment. As I looked back towards the ground, I saw Gray's right leg bent out like backwards donkey kick. I was then aware that PC Coombs had been kicked. I saw him step back. Gray was taken to the ground by myself, PS Gilder, PC Coombs and PC Hamilton Smith. This was to prevent Gray from assaulting any other officer. He was clearly agitated and I felt that his violent and abusive behaviour was increasing. Gray was put in a limb restraints to prevent him from kicking out. Gray then remained on the floor for a couple of minutes whilst he calmed down and transport was arranged. Gray was shouting out loud, "Fucking torture, fucking get off me. I will take this to Crown Court. I'll have you all, you bent coppers." Gray was conveyed to Trinity. So she doesn't even say that I was threatening Coombs. I admit threatening Coombs, but I don't think it was actually in the station. I think it was when I was in a cage in the back of a van, or in the back of a van being taken to the police station by Coombs. And of course, if Coombs was the complainant, he shouldn't be locked up with me for any long length of time at all, let alone for a long journey back to the journey to the police station, to the other police station, Trinity Road police station, because obviously that gives him a chance to intimidate me, and he's a witness in the matter, and he's also the complainant. Finally, we have the statement of none other than Reginald Gilder. I am Police Sergeant 2969 Reginald Gilder of the Avon and Somerset Constabulary, currently stationed at New Bridewell Police Station in Bristol City Centre. At 14:20 hours on Thursday, the 8th of April 2010, I was on duty in full uniform when I attended the area of the Front Inquiry Office in New Bridewell Police Station. This area is open to the general public during opening hours. I attended the front foyer in relation to a report of a male causing a disturbance at the location. Upon arrival at the location, I heard a male shouting very loudly and aggressively at the front office inquiry staff. The male was very agitated and shouting that he wanted a police escort at the Bristol Magistrates Court now, and it was our duty to protect him. He was shouting and gesturing at the front office staff in a very threatening manner. I could see that the front office staff were alarmed and shocked at the male's behaviour. I recognised the male as one Benjamin Gray, a white European male, 6'2", tall, of stocky build. He had dark cropped hair and was wearing a dark suit. I went out to the foyer area to speak to Mr. Gray. So this is dealing with the first incident. So all we'll say from that is that Gilder recognises me, but he doesn't remember that it was the me that complained to get him in trouble and upbraided by the PSD, by Power, who found against him in respect to not taking a witness statement. Convenient memory loss on the key issue about my past history with him. So we'll move on to the second visit. At 1500 hours on the same day, I again became aware of the fact that Mr. Gray had returned to the police station front inquiry office and was causing another disturbance. I approached the front foyer and I heard very loud shouting. I saw Mr. Gray sat on a bench in the front office public foyer. Mr. Gray was shouting at PC Stenner and PC Coombs. He was shouting, "Your thugs, arrest me!" He looked directly at PC Stenner and pointed, obviously it says Steiner, but he meant Stenner, and pointed his right index finger and shouted at her in a very aggressive and threatening manner, "You ugly bitch." So again, no F word used, which would of course be remembered if I was shouting the F word in a public place directly in front of either Stenner herself or Gilder. And both of those officers deny that I used the F word, or state clearly that I didn't use the F word in front of her. At this point, Mr. Gray stood up and continued shouting and being rude and obnoxious. Further police officers attended the area, including Inspector Davey, PC Hamilton Smith, and PS Lewis. Mr. Gray was continuing to shout and causing a disturbance and breach of the peace. Well, none of these officers are present before I'm arrested, so this is except Hamilton Smith. So Goulden and Lewis and Davey all are the officers that attend after the incident, after I've been arrested and I've been taken to the floor. Mr. Gray was continuing to shout and causing a disturbance and breach of the peace. This was the second occasion he had done so in the space of an hour. PC Coombs then arrested Mr. Gray for a breach of the peace. He cautioned Mr. Gray, at which point Mr. Gray became more agitated and was shouting. He then attempted to push past PC Coombs in an attempt to get away, at the same time moving aggressively towards me. PC Coombs... So the first we hear from Gilder about me moving towards him, let alone squaring up to him, is after I've been arrested. Whereas the two officers who arrested me, Hamilton Smith and Coombs, both stated they arrested me because I was already squaring up to Gilder. And indeed, at the time I was arrested, I wasn't even aware of Gilder's presence, let alone squaring up to him. And of course, we've already established that it was Gilder that comes over to me. He then attempted to push past PC Coombs in an attempt to get away, at the same time moving aggressively towards me. PC Coombs detained Mr. Gray. Mr. Gray was becoming more and more aggressive. I attempted to calm him down, explaining why he had been arrested, that it was unacceptable to shout at my officers. Of course, they're his officers, they're not public officers, public duty officers. Everybody, according to Coombs, is his property. According to Gilder, is his property. The officers are his property. I'm his property, effectively, because I'm simply being arrested on the fabricated basis that I'm committing a breach of the peace, or I have committed a breach of the peace, which is clearly not true because I haven't threatened violence, or even by his own testimony. And effectively, the poor Tesco customers 2 years before are his property, because if anybody feels like throwing missiles at them, that's fine by him, and he will threaten to arrest anybody that complains, or certainly me if I complain about getting that matter, in order to get that matter investigated. So he's saying he attempted to calm me down. Well, how could I be calm if I'm being falsely imprisoned and manacled, illegally assaulted, even by his own terms? And then, of course, I'm unable to speak to him for more than a tenth of a second, because as soon as I approach him and begin speaking, Coombs swings me round by the cuffs so that they dig into my bone and flesh. And starts to frog march me with this method towards the front door. Mr. Gray shouted aggressively back at me as he went to escort. So he's talking about Coombs now. He's supposed to be talking about Coombs, but he's saying, as we went to escort Mr. Gray out of the foyer level with the entrance, PC Coombs was to the left of Mr. Gray and stood slightly back. I witnessed Mr. Gray stop with extreme force and determination. He raised his right leg and kicked back in the same manner a horse would kick. So I've been upgraded from a donkey to a horse, which I suppose is something, although I'm actually a human being, and that's obviously not. So I've been upgraded to a horse, which I suppose I should be grateful for small mercies. This caused Mr. Gray's foot to connect with PC Coombs' right leg just under his knee. This caused PC Coombs to step back. This was a deliberate act and a direct assault on the officer. Mr. Gray then became more aggressive. Due to his violent demeanour, he was guided to the floor. This was to prevent him assaulting any other person. Mr. Gray resisted, and eventually he was restrained on the floor of the foyer. Mr. Gray continued to be very abusive, shouting and swearing, "Fucking torture, fucking get me off. I will take this to the fucking get off me. I will take this to the Crown Court." I repeatedly over and over attempted to calm Mr. Gray. Eventually, agreeing Mr. calm down, I explained again in full detail why he had been arrested and what was going to happen now. As Mr. Gray calmed down, I instructed the officers to sit Mr. Gray up, as I felt this would be more comfortable for Mr. Gray. So we don't have to finish off on that. I mean, that is those are the witness statements given by all the officers involved in my initial arrest, and they make it clear in boldest terms, they've simply kidnapped me. There's no legal basis for arresting me at all. Whether I'm swearing or not is depending on which officer you believe. It's equally between 2 and 2 whether I use the F word at all. Clearly, I deny calling Miss Stenner a bitch, and if I had done so, and if I've been, even if I've been done so, there's no question I could have been lawfully arrested under Section 5 of that, that allegation. But that obviously any arrest for calling somebody names would have to be proportionate and not necessarily involve rear stack handcuffs, and certainly the use of force that was used by the officers in question. But it's all irrelevant because, first of all, we've got officers that contradict whether I used the swear word at all, and secondly, and in any event, mere agitated behaviour, swearing, waving bags around, as found in the ruling of R.V. Howell, does not constitute a breach of the peace. A breach of the peace has to involve violence or threaten violence, and not a single officer suggests that I threatened violence or used violence. The manipulation of the truth, or the fabrication from some of the officers that I've squared up or approached Gilder, is not obviously evidence of violence. I'm allowed to approach an officer, especially if they're the senior officer present, and indeed if approaching them or squaring up to them was a form of assault or violence, well, this is what both Stenner and Coombs have done. They've come right into my personal space. they're not only approaching me physically, but they're making me face to face with their groins, and then looming over me, giving me only a couple of millimeters between myself and themselves. And long before any officer claims I was being arrested, Coombs puts his hand on my chest. Clearly, that would have been unacceptable if I had been a female. That would have probably constituted a sexual assault and been totally unacceptable. And it's just as unacceptable, I suggest, because even if I'm a male. And in any event, the ruling of Wood v DPP is extremely clear that an officer cannot simply lay hands on somebody, certainly with the sort of force that Coombs is using. And if they do so, that constitutes an assault. Certainly in this scenario, I'm also being falsely imprisoned. Coombs and Stenner both say that I have to push past Coombs. Well, why should I have to push past Coombs? Because the only necessity to do that is because they've completely sealed my exit, and therefore they are falsely imprisoning me. They are keeping me detained against my will, without any suggestion they're arresting me, any suggestion that I've committed a criminal offence, any suggestion they're about to arrest me for a criminal offence. And so all of that is effectively an admission to assault and false imprisonment. And of course, why am I even at the police station at all? Well, because the officers are perverting justice and using the situation over myself and Chapman and the formal criminal investigation by PC Townsend to prevent me getting to a court hearing. So they are perverting justice on that basis alone. They're clearly harassing me to the nth degree, because they're causing me major agitation and distress. There would have probably been, as I've already said, police officers at the court anyway, just to keep an eye on things between myself and Mr. Chapman. So all of that was at their instigation. And I've been assaulted and violently, I've been criminally assaulted and falsely imprisoned. And clearly, then they just lie about what I'm doing in the moments leading up to my kicking Gilder. I'm being illegally, not only was I being illegally restrained by Coombs when he put his hand on my chest long before he arrested me, but the arrest for breach of the peace was clearly illegal, because I wasn't committing a breach of the peace in the first place. I wasn't using any sort of threat of violence or violence. Therefore, the arrest was illegal. Therefore, the arrest was clearly kidnap, certainly assault. And given I was going to be arrested and taken somewhere else, it's certainly the conspiracy to kidnap. The cuts were put on too tightly. You can see from the injuries there. And then these officers pervert public justice and perjure themselves by falsely claiming I was squaring up to Gilder, when the footage clearly shows I was nowhere near Gilder at the time that I was arrested, and that Gilder himself approaches me is in the process of my being arrested and manacled by Coombs and Hamilton Smith. So they lie and lie and lie and lie in order to justify the arrest. Now, instead of my getting compensation for false imprisonment, instead of these officers being criminally investigated for the offences I've just set out, they know, or they think at the time, and it turns out they were right, that the judiciary and the barristers are so corrupt in Bristol that the judge that this goes before, and of course the whole listing process will be manipulated to get it in front of the right judge and the right barrister, CPS barrister, that the judge will collude in all this perjury, these are physical attacks on me. And of course, going back to 2008, because that's obviously relevant, because if nothing else, it goes to Gilder's bad character and motive, and of course, the modus operandi of the Avon and Somerset Police generally, and indeed the whole process. It seems to me quite clear, indeed, even from Inspector Power's report, if not from Gilder's conduct, certainly in this incident in April 2010, that they already know that the Albion Chambers, where Judge Martin Picton came from, where Mr. David Chidgey, who now acts, I think, as a recorder as well, is also from Albion Chambers, just as Judge Longman was from Albion Chambers, just as Judge Alexander Ralton, you may remember I mentioned him earlier, is from Albion Chambers, that they know this will go back to the same chambers, so they're all interconnected, they're all from the same club. Effectively, it might as well be called the Garrett Club, for all the kind of independence I might as well have had the trial at the Garrick Club for all the independence you're going to get from these old boys from the same chambers who all know each other, none of which was disclosed during the trial that I was involved in. It only came to light after I found out from looking at there's a plaque outside the Albion Chambers establishment which says who the judges were from that chambers and who the barristers still are, that they're all from the same chambers. And obviously, it seems to be quite clear that they know that there's actually a concerted effort to persecute and terrorise me because of all this evidence I have of other issues of corruption, and they can rely on the fact that also on top of that I cannot get legal representation of my own. So I'm going to get the judge, jury, and executioner in the form of Judge Martin Picton, who's going to connive in all these violence and criminal attacks against me, as well as against the children and innocent parties involved in the Tesco incident. And not only will connive in it, but when we come to the judgment, you will see the extent of lies that this judge will stoop to in order to have me convicted, falsely convicted, and banged up for many, many weeks as a consequence of what you've just seen and heard. Hello viewers, welcome to part 2 of Judge Martin Picton Must Fall. My name is Ben Gray, and this, as you are probably aware now, my YouTube channel at Newsworthy Publications, dealing with egregious corruption and collusion in all manner of criminality by various of the judiciary at Bristol and in the High Court, and of course the police and the CPS. Part 2 is entitled Two Trials and Judicial Review. This deals with the first trial at the Bristol Magistrates Court on the 1st of June 2010, in which I was prevented from any involvement in any proceedings. I was CS sprayed and held in custody in the cells below the courtroom, which obviously I'll come to in a moment. And having been convicted, I appealed to the Crown Court, and that is heard as a fresh hearing, as a fresh trial, and that was before Judge Martin Picton, and obviously I'll come to that in a moment. But dealing first with the Bristol Magistrates Court proceedings, as I've established in other documentaries as well as this one, I find it impossible. It is impossible for me to get any independent legal representation in any matter. As we've established, I wasn't provided with any legal representation when I was held in custody, and the matter was investigated. The incident, obviously I'm talking about the 8th of April 2010, was investigated by none other than Damien Hamilton Smith, who had already been involved in the complaint in the matter in 2008, when he and Reginald Gilder effectively colluded in the armed assault and perverting justice surrounding the armed assault at Tesco in February 2008. And of course, he was the one who involved in putting the handcuffs on me and arresting me illegally as I protested on the 8th of April 2010, and obviously had considerable part to play in the injuries I received, as you can see coming up on the screen here, already come up on the screen rather. So therefore he was investigating himself for the counter allegations that I did admit to the charges. The two charges were assaulting PC Coombs and using threatening or abusive words of behaviour, and of course I did admit some of the conduct, and certainly I obviously did kick him, and I did threaten him in no uncertain terms, but obviously on the basis that he was torturing and kidnapping me at the time that those words and actions were said. And of course PC Damien Hamilton Smith was fully involved in the kidnapping and the torturous abuse of the handcuffs that I think he put on personally and put on far too tight. So that was this is the sort of gruesome evil manner in which I've now been prosecuted. The CPS say there's a case against me, not against these officers, and obviously rely on the fact I can't get representation, and present the case to the Bristol Magistrate, District Judge Martin Picton, who I understand is now retired. And this, the actual event is going to be the part of yet a further documentary, because it's I don't want it to detract from the issues surrounding Judge Martin Picton and the 8th of April, and of course February 2008, of course, as well, and Inspector Power's investigation surrounding that. So it'll just become too chock-a-block with violence and other matters if I went into all the details of the corruption and the brutality surrounding how I was dealt with on the 1st of April at the Bristol Magistrates Court. A short version, without too much evidence being relied on other than the CCTV, which I'll show in a minute, but the short version is simply that I was I attended courtroom for the morning of the hearing, and the case, usually anybody that's got any knowledge of criminal trials at all, or any form of trial, but definitely criminal trials, is there's usually some housekeeping in the first thing as trials progress, before the trial itself progresses, so that one or both of the parties can make submissions on issues to do with shortfalls in the prosecution case, in my particular case. And one of the issues that I raised with District Judge Martin Picton, or attempted to raise with him as part of the housekeeping, opening submissions, is that the CPS had not disclosed the injuries I received as a consequence of my being restrained by the police officer in question. And of course, my defence was absolutely pivotal in terms of the unnecessary use of violence, even if the arrest was lawful, and that would be a matter to be canvassed at trial. At the time, obviously I should state that I had much less knowledge, and I've said in the previous documentary, of the law surrounding public order, breach of the peace arrests. I've been arrested so many times on breach of the peace because it is the police go to any situation, no matter who's in the right, is just arrest Mr. Gray and just spout off about breach of the peace, to cover all kind of situations that arise where I am usually trying to progress complaints of criminal violence against others, whether other officers or civilians or security guards in particular, and they will just say that the case is escalating and arrest me for breach of the peace, and then use the terror of being incarcerated and in custody to sort of dampen me down and oppress me, and then potentially try and bring a charge. This is exactly what has happened on the 8th of April 2010. And as I say, my knowledge there that I would have got to if I had been represented by a decent representation, solicitor or barrister, or both, they would hopefully have pointed out that under the ruling of Laporte v. Gloucester, and obviously the Wood v. DPP, both those rulings clearly established that I was assaulted first by Coombs. Just to recap, when he put his hand on my chest to stop me leaving, he's not only assaulting me, but he's falsely imprisoning me, because even by his terms, or any of the evidence given by police, I wasn't being arrested at that point. And indeed, several of the officers say that I had to barge past Mr. Coombs, or PC Coombs, in order to get through him. So the only reason I've had to barge through him is because he's physically restraining me and therefore effectively falsely imprisoning me and assaulting me under the ruling of Wood v. DPP, that states that any officer that lays hand on a civilian and not purporting or intending to arrest them is committing a criminal assault. If I'd known about that ruling then, obviously I would have gone straight in as an abusive process with the case to the judge and said this is illegal, because even on the evidence, on the CPS's own evidence, I'm being kidnapped, certainly falsely imprisoned and assaulted by Coombs, and then I'm being kidnapped because I'm committing no breach of the peace. Even if I'd squared up to Coombs, to Gilder, as alleged by some of the officers, not others, and clearly proven as false by the footage anyway, but even if I had, it wouldn't have amounted to anything like violence or threatened violence. But in any event, as I didn't square up to him, I didn't even meet that, vague suggestion of some kind of violence involved. So there was no suggestion from the officers And indeed, Gilder himself, who was obviously would have known if I'd squared up to him, made no allegations that I'd squared up to him. He couldn't do because the footage proved I didn't, and he certainly gives no indication that I've used violence or threatened violence at all. So the breach of the peace was carte blanche arrest. And of course, almost certainly, District Judge Martin Brown, he's supposed to be an experienced lawyer. The reason why we have district judges as opposed to lay judges more often is because district judges are supposed to be more experienced and more learned in the law than obviously lay judges or magistrates who don't know the law at all and have to get all their information from the legal advisor, who him or herself often doesn't have any qualifications as I understand it, themselves. So you can have a magistrate court with, in fact, nobody with any knowledge of the law from any quarter, except, of course, the CPS. And, of course, the CPS, and I don't even remember the name of the CPS officer involved or the CPS representative. He probably wasn't from the CPS. He was probably a hired gun from a barrister's chambers. But it's so long ago, and I didn't pay attention to that either. But all that matters is that there was no lawful justification for my detention. I was entitled to resist it because there's no question I was being kidnapped, and I certainly had reasonable suspicion that I was being kidnapped at the time and therefore was able to use force. But at the time, I certainly knew I was entitled to the copies of the injuries, for the records taken of my injuries to prove that even if I was being lawfully detained, I was being assaulted anyway, and I was entitled to resist because the force used was far too excessive, and again we can see from the footage anyway from Coombs twisting the cuffs and twisting me around with the cuffs like I'm less than an animal, clearly inflicting pain and degradation and so forth, which I was entitled to resist. But of course the injuries were pivotal to proving the extent of illegal force used. So this was my position, and I very politely stood up, as I do obviously when I'm in the courtroom in any situation, unless I'm obviously being stitched up every which way from Sunday and my fate is sealed. But in this case, I was going on the basis that District Judge Martin Picton wasn't a complete crony puppet of the police and CPS, and was going to be independent. But before I'd even stood up, there's already Tina Brewer, the first witness to give evidence against me, in the stand, which again is highly unusual because there's usually some housekeeping and abusive process arguments can be raised and so forth, and I clearly need to establish the medical records in order to question Miss Brewer about them, assuming the trial was legal at all. And Judge Brown, like some sort of imperious Roman general, just ordered me to sit down and said, "Be quiet, we're going to crack on with the trial." And clearly knowing that if I didn't have the medical records, I couldn't properly question Brewer, who had been witness to the use of force used by Coombs and so forth. And obviously I need to prepare. Article 6.1 of the 6.3 of the Human Rights Act says that somebody has an accused should have the basic minimum rights, which is to prepare for the trial and facilities and time to prepare for the trial. Obviously I didn't have any preparation of the trial because I hadn't received the basic key documents. And of course, the fact that the CPS aren't disclosing them shows they're not interested in examining or getting the police getting an independent examination of how these injuries came about, or indeed what the footage showed. Because they know that they've got this pocket judge, Martin Brown, who if somebody's unrepresented, especially, doesn't care a single penny piece for the rights or basic rights of a defendant, especially if the police are the complainants. And they're basically a little gangster mini-state within the judicial system. But anyway, I mean, the point is that Judge Brown just ordered me he was going to crack on with the trial. He wasn't interested in anything I had to say about not having the records to prepare for the trial and to question the witness about to give evidence. And I just said, this is a complete stitch up. It's a kangaroo court. I'll have no part of it. I'm clearly not required here in these proceedings. So I gathered up my paperwork, and I had a large rucksack at the time, and headed for the door. And at this point, Judge Brown ordered for the buzzer to be the alarm to be pressed, so that brings the security guards from different parts of the building. which included Gavin Manley, who was, as we shall see in a moment, was one of the security guards who was still under investigation, because the conclusions of the investigation weren't made by PC David Townsend until August. And this was the beginning of June. So he was one of the security guards was still effectively under criminal investigation for assaulting me in February of that year, of 2010. And obviously we've seen the images from that assault. And he was one of the security guards, along with a Mr. Warner, I think a Michael Warner, or certainly surname Warner, and a Miss Littlejohn or Littleton or some little something, or Miss Little, I forget her name, but a black female security guard called Miss Little, and Mr. As I say, Mr. Warner and Mr. Manley, and they all piled into the vestibule, the gap between the courtroom and the main hallway. And so there's no CCTV there that was ever produced as to what occurred. But of course, as I'm leaving, I go through the first door in order to get to the second door. And as I'm passing through in the middle of the vestibule, that's when all the security guards piled in and restrained me. And Gavin Manley was particularly vociferous in his restraint, and he actually put his arm across my throat, preventing my breathing. And I had to sort of lash my. I was trying to use minimum force. So I wasn't whacking people with fists. I was just sort of smacking them out of the way, trying to break free of this restraint, which was clearly illegal. And as I was doing this, the door from the hallway opened, and there was a woman I later found out to be called PC Jane Ellis, or WPC Jane Ellis, but I don't think we use the W anymore. And she, within a few seconds, got out her CS spray. She wasn't even a fully fledged police officer. She was there apparently shadowing Ross Coombs as a sort of learner, as a novice, getting to know the ropes, although why that would involve her attending a trial is a bit sort of odd, but in any event, that was her presence there. She was in full uniform, and she just said spray, and she sprayed me and all the security guards at point blank range with the CS spray, causing us all to cough and splutter and recoil from the effects of the spray. And I got so much of it that I simply collapsed to the floor. And at which point Coombs and Hamilton Smith joined the fray, and they jumped on top of me and rear stack handcuffed me, as their sort of expertise in doing. If their only expertise, but they're certainly proficient at the rear stack handcuffing of Mr. Gray. And they handcuffed me and then dragged me to my feet. I'm gagging, obviously, from the effects of the spray. One of the main effects is to cause massive, lots of crying and snot from the nose to pour out. So as I'm being held by Coombs, who's now also suffering from the effects of the spray, he's wiping the snot from his face and then wiping it over me as he's holding me. And we can see all this from the footage. And then I'm permitted to sit down for a few moments, and then as I've sat down, I'm just about recovering myself, and then Hamilton Smith sort of looms over me, grabs me by the handcuff dividers, yanks the cuff dividers up over my head, and then him and Coombs frog march me out of the court building and shoved me into a waiting police van. And the reason why I was kept in a van, as I later found out, was because District Judge Martin Brown was still orchestrating the investigation into what had happened in the vestibule. He was a witness to events because the door was actually open as I was going through into the vestibule. So he was a witness to events. He was also the person who could press the alarm, so he had caused the security guards to attend. And so, ergo, he shouldn't have had any control over the investigation. Obviously, it needed to be investigated independently. And he ordered for me to be kept, whilst I was in the cage, to be taken back into the court building and then held in the cell, one of the cells or dungeons below stairs in the court building. And then he just simply carried on with the trial. The fact that I was soaked in CS spray was of no concern to him. Indeed, probably assisted certainly the police in getting the conviction, because I couldn't. At one point, he sent a dock officer down to ask if I wanted to attend the trial. as I was literally drenched in CS spray. I was not able to have access to fresh water. I was not able to change clothes. So all my clothes were drenched, even though I obviously took my jacket off. My t-shirt was drenched, my trousers were drenched, therefore aggravating the CS spray. I think this CS spray has changed now, where it's parbour spray these days, but at that time it was, I think, made from some capsicum type of chili, or a mock, a fake version of that sort of substance. So it's literally burning acid into my face, into the rest of my skin. So I'm being burnt alive in literally some medieval version of, sort of like a version of of the Inquisition, of the auto de fe, where people were burnt alive. Thankfully, not to death, but for all they know, it could have been, because I didn't have the basic aftercare that I'm entitled to as somebody who suffers the effect of CS spray. As I say, the judge simply carried on with the trial, convicted me, I think, the following day, remanded me. So I had to go to, he did me for contempt of court for walking out of the court building and, the courtroom. I wasn't intending to leave the building. Obviously, I was still obliged to attend bail. But I was on bail, and therefore, as far as I understood the law, I was able just to sit out the hearing and wait for my conviction, which is obviously coming along the lines from this utter crook, Judge Martin Picton, and not involve myself with what was clearly a legal trial. And of course, if the judge wanted me to sit in the dock, I would have probably facilitated that. But at the time, as we shall establish in a minute, I was permitted at that time to leave the court building, to leave the courtroom rather than the court building. So anyway, I'm convicted the following day. I'm given, I think, a total of 38 weeks, which included a sentence for both of the assaults, the activated 16 weeks from the 19th February conviction in terms of the security guards, in terms of all those fabrications, which again is going to be a matter for a separate documentary. So he activated the 16 weeks. He gave me another, I think, 9 weeks or something for the assaulting of the officers, or I lose count. It'll come up on the screen eventually. But altogether it was 38 weeks, which included 1 month for the contempt of court, and all of which I appealed whilst I was in custody. But of course, in the meantime, I even went on hunger strike for a period. I was so shocked and suffering the effects of the abuse from the CS spray. I couldn't even get a cold shower, because the showers at the time at Hawfield Prison were automatically hot. So I had to be scalded even further from the effects of the CS spray. The whole layers of my face and my chest skin just simply peeled off from the effects of being burnt by the CS spray. But in due course, I got my act together to appeal, to lodge my appeal, which has to be lodged with the magistrates' court. And I think 2 weeks to the day after the incident, or within about 2 weeks, Judge Martin Picton directed a video link hearing and gave me bail pending the outcome of the retrial, which was now filed with the court. And he even commented that one of the reasons he was giving me bail, that it wasn't very serious, taken at the highest. But of course, it was serious, because I was the victim of the most serious perjury and perverting justice and torture, and certainly assault and kidnap and false imprisonment that anybody can undergo. Bearing in mind that false imprisonment or false imprisonment and kidnap can be perpetrated simply by deception, so where it involves no violence at all. But in my case, it involved excessive violence, extreme violence. And of course, that then resulted in the kangaroo court before District Judge Brown, who just tried me in my absence, knowing that he was a witness in a criminal case in respect to why I was restrained and CS sprayed, almost literally in front of him. Well, certainly part of the incident did, in fact, happen in front of him. Viewers, that is the trial, in quotation marks, but of course I use the word again sarcastically, because it wasn't a trial worthy of the name. It was simply it was, as the title suggests, it was a kangaroo court of the worst kind. It was of a kind that hopefully most people wouldn't believe could occur in the great modern human rights loving, law-abiding, country that we live in. So, just as an epithet to that, or an afterthought, it's worth pointing out that and also to give you an example of the corruption involving the press as well, the Bristol Post, or the Bristol Evening Post as it might have been called then, I'm not entirely sure, but it's still online, it's still the local press for Bristol and the surrounding area, and of course often refers to cases outside Bristol itself. And obviously they're the first port of call for any stories that then hit the BBC or the mainstream press. But it was published a couple of days after the incident by Bristol Post, which is referring to myself, talking about me being CS sprayed after I had assaulted two security guards. That was the allegation. The allegation was that I had assaulted two security guards. But in due course, and of course, an important point that I should have made earlier is that I was acquitted. I was tried. I was brought to trial at Bath Magistrates Court before a district judge, Calloway, who, again without legal representation, who ruled that I couldn't be prosecuted. He ruled that no case to answer, one of many, many cases that are dismissed as no case to answer or abuse of process. Stating that the trial couldn't continue. I didn't need to give evidence in my defence because it was clear that the security guards had no right to restrain me under Section 53 of the Courts Act 2003, which states that the security staff, and I've referred to it when I was discussing Gavin Manley and Mr. Chapman when they restrained me in February 2010. That they had to have reasonable force if somebody's, that there are certain criteria that somebody has to be doing in order for anybody to be restrained under the Courts Act, under the powers given to security guards at the time, and that has to be if they're disrupting court process and so on and so forth. And obviously the judge found I didn't meet any of that criteria for simply walking out of the court room. At the time, the only option open to District Judge Brown was to issue a warrant for my arrest for not attending the hearing, but that had to be done through the proper process of issuing a warrant and then having me arrested, even if it was just outside in the court in the hallway of the court building itself. But the guards themselves at that time didn't have any powers or right to restrain me. Simply on the basis that I was walking out of the courtroom. I could have been going to the gentleman for all they knew, and in any event, that was ruled. That was one of the reasons, and the other reason was that the evidence given by PC Jane Ellis was completely contradicted. They said, she and Gavin Manley both said that I had started hitting Gavin Manley the moment I came through into the vestibule. But the other two security guards, and of course this is where District Judge Martin Brown might have been helpful, because he was a witness to the initial, with the door still open, me coming through the vestibule. The other two security guards said the complete opposite, that I was restrained immediately just for simply trying to walk past the security staff. Again, the evidence given by Manley and Ellis was dismissed, was effectively clearly perjury, and dismissed anyway by evidence to dismiss the case against me, because Ellis's version of events was simply incredible. I mean, for a start, I had a rucksack on me and I had a load of paperwork. So how I could be lashing out, immediately hitting the guards, and why that wasn't noticed by the other two security guards who actually arrived first, again proved the falsity of the assertion that I had hit Manley. But long before I was acquitted, indeed a couple of days after the incident occurred, as I was saying, the Bristol Post saw fit to publish that I had actually committed an assault against the guards, and that's why I was CS sprayed. And you can see from the footage, or still from the footage rather, you can see that the black gentleman there who's doing something on his mobile phone, he's almost certainly a lawyer that I think I might have had business with him, but obviously I can't see his face that clearly. But in any event, he's a solicitor, and he's not the slightest bit interested in the member of the public who's just been gassed, CS sprayed in the face, and he and the security guards are suffering the effects of the CS spray. And he's clearly a witness, so he should have been questioned by the police as to events. And of course, I didn't even get to give a statement in relation to that. I was simply carted back to the magistrates' court, as we've established. So District Judge Brown was also perverting. Not only was he colluding in the perverting justice and all the skullduggery surrounding the 8th of April incident that he was trying, but he was also perverting justice by interfering with the proper investigation that should have unfolded after I was arrested and accused of assaulting. Indeed, it was initially ABH against the security guards, which justified detaining me in the first place and using restraints. But of course, that was never investigated because the judge ordered me back to cell, so I couldn't give a version of my version of what had happened. And so it was just simply the statements that were taken. And when the statements were taken, they in any event contradicted each other anyway, because Mr. Warner completely contradicted, Mr. Warner and Miss Little completely contradicted Manley as to who hit who first. There was, in terms of Manley saying that I'd hit him, and of course PC Ellis wasn't witness to that because she only came moments after the incident, as it was already unfolding in the vestibule and had been going on for a good 30 seconds before she even arrived. Although she says she was in the courtroom, but I think that was proven as false as well. But in any event, I was acquitted. I was found to have been the victim. I litigated in due course, and that was thrown out by the corrupt judges in London. And that, as I say, that's the matter for a further documentary. So, but the key issue is that it was thrown out. But you can see the level of corruption by the Bristol Post, that they're already publishing the fact that accusing me of being the assailant, without any moral scruples, any concern for the veracity. And of course, where have they got this information from? It must have been from the police, either the police or the CPS, who are effectively in their pocket. So the so-called faultless state, who are supposed to be holding the police and the courts and everybody in power to account by independently, reporting to the public, the facts that as they understand them, they couldn't possibly be stating as fact what was an allegation that I was protesting my innocence in that hadn't even gone to trial. Indeed, I wasn't even charged with the initial grounds of arrest. And they're reporting it as I've already been found guilty of the assault. And I even litigated the World News Organization who ran the Bristol Post, and they denied everything. And as I say, that'll all be the matter of a much more detailed documentary with blow-by-blow description. But the main thing is, of course, did I have a fair trial before District Judge Brown? Well, of course not. I was being burnt alive in the cells down below, and actually Judge Martin Picton was just, Judge Martin Brown was simply just carrying on as though I didn't exist, and just rubber stamping the conviction on behalf of the CPS in complete contravention of every single principle or legal principle surrounding fair trials that this country is supposed to, be a bulwark in supporting. So I'm given bail. I recover eventually from the effects of the CS spray and all the ordeals of that, having only just recovered really from the terror and assaults and violence on the 8th of April, to say nothing of February and then Tesco's before that. I assume it's in my acquittal is in the bag. There's no way that it being a full before a full. I've now obviously got the medical records because there has been a provisional hearing, I think, at some point where the medical records were ordered finally to be disclosed. But you just assume with a proper circuit judge, an experienced judge, criminal judge, that there's going to be no way that this conviction is going to be upheld. Even if never mind that the trial itself was completely illegal, just on obviously on the substance of the case, as I've discussed in my first documentary in Judge Martin Picton Must Fall. But you know, Judge Martin Picton just lied and lied and lied and whitewashed and lied in much the same manner as Judge Ralton did. If you go to Judge Alexander Ralton, The Demon Butcher of Bristol, that's another documentary in which he lies his corrupt head off in covering up a almost identical situation. Effectively, as most of these documentaries will be about, and all my arrests are, just repeating the same sort of Groundhog Day of terror and torture and kidnapping, all orchestrated. And of course, this is the key point, about mainly and certainly originally from Albion Chambers barristers and former barristers and now judges, because of course what I didn't understand and didn't know at the time, you know, amongst all the my other ignorance surrounding knowledge of the law and so forth, is the fact that Judge Martin Picton was a former barrister of Albion Chambers, and yes, of course, David Chidgey, who was who led the prosecution against me, who represented the CPS, he too was from Albion Chambers. So of course, they will be well aware of my complaint that I was the victim of torture, of the footage proving hand over fist perjury from all the officers involved, proving that I had absolutely reasonable justification in attending the police station in terms of the violence and the ongoing criminal investigation in terms of Mr. Chapman's conduct that was being investigated by PC David Townsend. And of course, you know, the key point is the footage, you know, cannot be argued with. It proves exactly what has occurred and knocks everything that the police have to say into a cocked hat, because everything they said was clearly and utterly made up, and therefore was itself criminal misconduct, perverting justice and perjury. And so, as I thought that I'm finally going to have my day in court. I'm not going to get into a situation, hopefully, in a much more staid and conducive and atmosphere of Bristol Crown Court, where the security staff are, you know, I've known them, I've got to know them over a period of time, and so I'm not too worried about them getting handsy. And of course, as we've established, it wasn't actually necessarily the security guards' fault that they were involved in the first place. Of course, what they do and say afterwards was their fault, but the initial incident in Bristol Magistrates Court was, of course, the fact that the bell had been rung just for the fact I was walking out of the courtroom. But in any event, obviously they know that the more serious the counter allegations from me, the more they need an absolute guaranteed outcome and a cut and dried stitch up from the Crown Court. So, of course, if it's going to be an Albion Chambers barrister and an Albion Chambers prosecutor, then obviously they're going to know each other through their contacts through Albion Chambers. They're going to have mutual friends. They may even be friends themselves. They all go to the same club and so on and so forth. So they've all got a vested interest in protecting the reputation of Albion Chambers generally. And of course, what David Chidgey is doing is he's going to stand there as the wicket keeper for every single corrupt act involved in these proceedings, not simply from the officers or the CPS officers who involved in the prosecution, but indeed Martin Picton himself, who it would have been well known to David Chidgey was perverting justice by having me kept in cells rather than have the matter investigated, for which I was restrained when major armed violence. Again, you see this issue of armed violence, because of course with the Tesco incidents, that was armed violence in which children, as well as myself, or elderly people and disabled, vulnerable people were in the firing line for the missile attack on myself. And of course we'll come to it again, because Martin Picton is involved, as is David Chidgey. They were involved in that because they had all knowledge of the paperwork surrounding that hadn't been properly resolved by Inspector Power by a long margin. And then, of course, the violence that unfolded in the New Bridewell police station on the 8th of April, That again, anybody could have walked into that quite small reception area while there's this mad scrum going on between myself and these officers on this complete fabricated assertion that I've breached the peace when I hadn't done anything of the sort. And then obviously the CS spraying, again, the magistrates court building could be used, the guards, I mean, at least Warner, gave honest account that I hadn't hit anybody when I came through. I was simply trying to walk past him, and I was restrained by Manley. So he was, a reasonably honest security guard who, was just simply responding to the bell. But he got a face full of CS spray. He got burnt alive, and he was completely innocent to the proceedings. And of course, anybody could have been in the vicinity of that CS spray. And again, armed violence was used, and there's really not much more to add except to go through the judgment of Judge Martin Picton, which at least he was good enough to provide, and of course then the decision by now retired, thankfully, Mr. Justice Stephen Silber, who then considered my judicial review of the decision of Judge Martin Picton. But of course, in fact, Judge Silber didn't do that. Mr. Justice Silber didn't do that, who, as I say, is thankfully retired. He delegated the judgment to Mr. Chinwezi, who was from the CPS, who the judge actually asked him to address the grounds for judicial review. But let's not jump ahead of ourselves. Let's look at what the judge said. And obviously bearing in mind the footage that we've seen in the first documentary, and maybe I'll show again as we assess the judgment. So the judgment was made on the 7th of March 2011. I can't remember the exact dates of whether this was made a few days after the trial or what, but I was obviously convicted around March 2011. And this is what the judge ruled. The charges. Following a trial at Bristol Magistrates Court, the appellant was convicted of 2 charges. 1. Assaulting P.C. Coombs in the execution of his duty, contrary to Section 89(1) of the Police Act 1996. And 2. Using threatening, abusive or insulting words or behaviour or disorderly behaviour with intent to cause P.C. Coombs, P.C. Stenner and P.C. Hamilton Smith harassment, alarm or distress, and thereby causing that person or another harassment, alarm or distress contrary to Section 4A(1) and 5 of the Public Order Act 1986, the proceedings. Headline. This appeal has taken a very long time. That is so despite efforts made to try and retain focus and proportionality in the range of the process. The appellant, we anticipate, will have a very different perception of these proceedings. He has an apparently boundless energy and enthusiasm for the appeal process that we have been undertaking. Whilst he was liking the examination of what went on in the foyer of New Bridewell Police Station, as well as on the way to and at Trinity Road Police Station as being torture for him, we do not accept that the process of hearing this appeal can be sensibly likened by the appellant as amounting to something that might merit the description so far as he is concerned. It is a very long-winded way of the judge saying it's not torture on the part of the judge to make me relive the ordeals that we've seen unfold on the 8th of April at New Bridewell Police Station. It seems to us that the appellant positively revels in litigation and that his protestations that he is disadvantaged by the absence of legal representation do not bear examination. Well, the main thing that the Judge Picton is ignoring is the fact that it's my right under the Article 6.1 of the Human Rights Act, Article 6.3 of the Human Rights Act, that anybody accused of a crime is entitled to legal representation if it is in the interest of justice. And usually when somebody's been prosecuted and faced prison, then it's in the interest of justice. What evidence he has that I revel in the litigation process, well, of course, he provides none. He's just as he's quite happy to fabricate anything that comes into his head, including that he thinks he's God and can be inside my head, and try and claim that I was actually enjoying being in court with this absolute monster, having to relive these ordeals when it was clear that I was the victim, and so, as we should come to, just as much as he then fabricates anything else or whitewashes the evidence that clearly proves my case. He just says that I enjoyed being in front of this judge and undergoing prosecution, and then obviously going to prison afterwards. Presumably, knowing that I've got the because I've done 2 weeks, I've still got another 16, 17 weeks of custody, doing half the sentence looming over if he finds in favour of the prosecutor of his friend from Albion Chambers, David Chidgey. But obviously, where is the evidence that I've enjoyed it? Have I, at some point in the proceedings, have I said to the judge, especially under oath, I'm really enjoying this litigation? Obviously not, otherwise he would refer to it. So this is simply him lying his crooked teeth off to pretend that he knows about what my mindset is or what I am enjoying and not enjoying, without any evidence to one way or the other. But anyway, we'll progress. As the judge presiding over these proceedings, the responsibility for the amount of court time they have occupied is mine alone. Should anyone ever come to have to examine this case and wonder why I did not curtail the appellant to a greater degree so as to reduce the amount of court time expended upon issues that normally would have taken perhaps half a day to a day, they should consider the transcripts of the exchanges, should such ever need to come into existence, and ask themselves the question whether they could have done better in terms of controlling the appellant, which I am quite sure they could, and have kept the appellant engaged in with the court process so as to remove from him, as far as possible, the capacity to legitimately assert that he has not had a fair opportunity to advance his case. I emphasise legitimately because we are quite sure that the appellant will not believe he has had such an opportunity. It is difficult to envisage a process that would ever satisfy the appellant's powerful desire to litigate the circumstances surrounding these charges and or to relitigate past incidents and disputes, primarily but not exclusively relating to the police, a number of which the appellant chose to volunteer on many occasions, which resulted in various other civil and criminal court proceedings that have occupied the magistrates, Crown, County and High Courts. Well, obviously, as we shall see from the rest of the judgment, he doesn't indicate for them almost entirely what these matters were that I've referred to, but his suggestion that the trial should have lasted between half a day and a day. Well, the incident itself lasted around half an hour. There's footage to examine. There's all the witnesses to the case. There's the police. There's 1, 2, 3, 4. At least 4 officers. There should have been more because a lot of the police witnesses who attend, we can see at the end of the incident on the CCTV, weren't called at all, and they should have been. Then there's a no case to answer submission. There's the injuries to examine. There's the medical examiners who verified the extent of the injuries we received. There were witnesses. There was a witness that had to be summoned. So part of the reason for the delay was that the CPS failed to locate a Mr. Finlayson, I think his name was, who was a man that was locked up with me in the cells at Trinity Road Police Station, or not in the cells, but in the waiting area, and gave evidence eventually, as we shall see from the judgment, that the cuffs were on too tight. That was all to do with the CPS, nothing to do with me. The judge himself ordered for the witness to be summoned, and they had to find him, and then they lost him or something, and it went on forever. But how on earth the judge could envisage that somebody could go through that whole trial, question all the witnesses about the key issues, especially when all their evidence contradicted themselves and the CCTV. So in order to examine properly what those officers are saying compared to what's on the CCTV, each witness would have needed at least an hour or two to cover all the contradictions. Then there's a no case to answer application, assuming that there's not an abusive process application arising from all the criminality from the police officers. And of course, the irony, of course, already, the hypocrisy of the judge is to waste court time and public money blathering on about stuff that has nothing to do with whether I was guilty of the crimes alleged, and what my defence is, and what evidence I had given to support what evidence was given from either party to support the position that I was the victim or that the police were the victim. He himself is wasting time, just as he did with the trial itself, by doing everything and going in for the personal attack. It's the personal nature, of course, derives from the fact he's from Albion Chambers, and Albion Chambers are involved continually in stitching me up. We see the judgment. If you look at the judgment from Judge Rolton as well, he goes on and on about my personal relationship with the library, with an inanimate object, a building, no less. It takes up a whole chunk of his discourse, and it's all about trying to undermine my confidence, attacking me as a person, using the power and time and money that the the state is giving Judge Picton to examine my guilt or innocence or my counter allegations, to blather on about stuff that has nothing to do with his role as a judge. Indeed, he's showing his bias with every single word he's saying about how I love litigation and how it's, he was out of control. Of course, if I was that out of control, he would have done me for contempt. I just make the applications that are relevant. It's the judge that's out of control, clearly, because he's doing everything and anything but fulfilling his role as an independent judge, assessing the merits of the case. We'll carry on with what he has to say. This appeal has generated a number of legal issues upon which rulings have had to be given. They have included a submission of no case to answer, which we rejected, and a request that I recuse myself, something I declined to do. We will not revisit those rulings, save and insofar as is necessary to do so in setting out our reasoning in respect to the matters to which this decision is directed. Those matters are A, abuse of process, B, guilt or innocence in respect of the charges. The facts. We will endeavour to set out the basic and less controversial factual background and then attempt to identify those relevant disputed areas of fact that touch upon the decisions we need to reach. It's so long-winded and verbose, isn't it? He's deliberately, you're losing track of what he's actually saying by the time he gets to the end of his lengthy sentences. On the 8th of April, the appellant was scheduled to attend a hearing at Bristol Magistrates Court. There had been a prior incident at the court involving the appellant and Mr. Chapman, employed there as a security guard. By way of digression, that prior incident was one of a number of conflict situations about which the appellant expressed himself as being seriously aggrieved. As already indicated, the appellant would have very much wanted to expand the scope of the factual inquiry undertaken in the course of this appeal into the circumstances surrounding that event. You know, it's very simple. I accused Chapman of assaulting me. He was under investigation for an assault. Where's there any mention of an assault? A conflict situation, aggrieved, blah, 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 everything except the simple fact. The fact was that I was complaining of assault. I accept it's not going to be a fact, even though by now, obviously, Townsend had carried on his investigation. It's not necessarily going to be a fact that I was assaulted, but it was a fact that I was alleging assault, which is why I couldn't attend. He doesn't even say the context of why I was complaining about the Chapman assault, which was that I couldn't attend the hearing that I needed to attend. We'll go on. As already indicated, the appellant would have had very much what it says. He is apparently possessed of an equal and barely containable enthusiasm to do so with regard to many other incidents, including, for example, one at Tesco's, which was investigated by a witness from whom we heard, Sergeant Gilder, a matter the appellant suggests is relevant to potential bias on the part of that witness, but also one of the foundations of the appellant's lack of confidence, which he says he feels with regard to his treatment at the hands of the police and his largely, but not exclusively, unsuccessful track record of court proceedings arising therefrom. Again, the issue about Gilder and Tesco's is, of course, the armed violence against me and other innocent users at the Tesco's is by 1,000 light years more serious than my kicking a police officer who is clearly twisting me up and kidnapping me. And of course, the fact that Gilder was reprimanded and told off by the PSD and was found to have engaged in misconduct, although not serious enough to be dismissed or face further prosecution. And of course, I'm alleging all the time perverting justice, collusion and armed assault, none of which gets mentioned by this spinner, Judge Martin Picton. What he's actually doing is he's saying, I'm hand in glove with the armed assault. I'm hand in glove with the perverting justice, with the perjury. The police officers, you remember where Gilder refers in his witness statement to, what I'm doing to his officers, meaning, in that case, Coombs. This is what Martin Picton even referred at some stage during these proceedings about how in the old days the judge used to be the police officer, and they would simply change hats. And he's putting the fear of God into me, because he views these police as his little private militia. That's what they are, and they can do anything they like to me. They can lie, and not just to me, to the public, both in terms of perverting justice and in terms of armed attacks against me. You know, there's the other incidents he's obviously referring to is the CS spraying, and the gassing that I received in as an innocent person in the magistrate's court during the first trial, the twisting up by Chapman, the armed assault. None of the actual, even the allegations, gets mentioned by this crook, Martin Picton, much less the evidence to support the allegations. He's actually saying is almost irrelevant. That's what he's actually dismissing it as completely irrelevant. If there's evidence the police are engaged in criminality, that in terms of the perverting justice alone carries up to life imprisonment. Nothing I'm doing or accused of doing at its highest merits more than a few months in prison. There are summary offences, whereas perverting justice carries up to life, and perjury carries up to 7 years in prison. So, and where's there any mention of the perjury, perverting justice, or assault? Just this verbally, he might as well be just quoting from Proust for all its relevance, or Proust, or whatever, you know, who's famously verbose and uses endless sentences that you've forgotten when you get to the end of the sentence what he was saying at the beginning. And that's what he's doing here, is deploying verbiage, what they call pettifogging, in order to cloud and just lying his head off. Because of course what he's saying I'm alleging, or is what the basis that why I'm referring to these incidents and these findings, is to prove the corruption of the proceedings generally, not as some as he puts it, to proceedings arising therefrom, etc. Anyway, the appellant has expressed himself forcefully to the effect that he has no confidence. It doesn't matter whether I have confidence or not. That's not finding of guilt or innocence. What matters is the evidence of corruption and criminality and collusion in criminality, be it armed assault, be it torture, whatever. That is what should be the focus of the judge's attention, and would have been the focus of attention if he wasn't a crony listed from Albion Chambers for the specific purpose that the CPS was from Albion Chambers, because they are all part of the same anti-Ben Grey club. And of course, the more corrupt they are, the more they have a reason to close ranks and become more of a club. He does not comprehend the need to avoid digressing into satellite issues that cannot sensibly be resolved in the context of litigating his guilt or innocence in these particular charges. The actions in the foyer of the New Bridewell police station were captured on CCTV. It is of good quality and illuminating. It would have been more illuminating if it had sound, but such is not recorded by the sound system installed there. Events at Trinity Road police station are likewise captured on CCTV, but that material has the benefit of a soundtrack. All the CCTV material has been the subject of exhaustive examination. Oh yes, of course. So there was the CCTV. I haven't dwelt on it because I'm simply not going to relive the ordeal of being trussed up and the way I was treated when I was in the Trinity Road holding area, which was for more than an hour in baking heat. So even that, according to Judge Picton, could have been dealt with within the same day. So we're going to have all the witnesses give evidence. An hour of footage of myself at the Trinity Road police station, another half an hour of footage, the injuries, my no case to answer submission, my giving my evidence myself, including clearly background issues. The judge accepts that they were at least admissible, otherwise he wouldn't have admitted them. So the background evidence of Gilder, all of that was supposed to be between half a day and a day. What he means by half a day and a day is simply guilty, send him down. That's what he really means by half a day. Sergeant Gilder, as the first witness from whom we heard. My summary of parts of the witness evidence appears at Annex 1, including the evidence given when he was recalled at the appellant's request. I have not troubled to correct all the elements of shorthand that I utilised in attempting to note his evidence. The appellant has repeatedly expressed his concern that these proceedings be subject to public scrutiny. As the evidence was given in open court and anyone who wanted to observe the process could have done so had they so chosen, I do not propose to read my summary of his evidence into the record of this decision. I have also included in Annex 1 my note of the answers given in cross-examination that I considered to be relevant. We then heard from PC Coombs. So, I mean, even if I was supposed to go backwards and forwards from the judgment, or the public were, to his annexed notes about what evidence Gilder gave and what questions were asked, I mean, this is pure madness. There's only one simple question. Was I committing a breach of the peace? Which the judge won't address. We'll see that when we get to the end of the judgment. But that's the only issue for Gilder. Was I being arrested lawfully, i.e. had I committed a breach of the peace to justify arresting me to prevent a further breach of the peace? Was the form of arrest proportionate, i.e. was excessive use even if it was lawful? And insofar as what misconduct did I commit? Well, Gilder doesn't say anything about swearing as far as I recall, but in any event, I wasn't arrested for swearing. I was arrested for a breach of the peace. The breach of the peace, if it was caused at all, or there was alleged at all, it was to do with squaring up to Gilder. Gilder gives evidence that I didn't square up to him. He made no suggestion that I squared up to him, and in any event, the footage proves it didn't. That's all the judge has to do. He doesn't have to go on about annexes and quoting verbatim from what the officer said. And of course, in terms of motive and bad character of Gilder, in terms of the finding against him, well, we'll come to that in a moment. We then heard from PC Coombs. Again, again at Annex 2, I have appended my notes of the relevant parts of the evidence. Well, so does Coombs contradict Gilder? He does hand over fib, because apart from anything else, it's Coombs that accuses me of squaring up to Gilder, and Gilder makes no suggestion that I've squared up to him, and the footage proves he didn't. So in terms of the perjury that Coombs has said that I squared up to Gilder, of course, that's whitewashed by Judge Martin Picton, because he won't even refer to anything that Gilder says on any of the key issues. And next to PC Goulden, the evidence of PC Hamilton Smith is noted at Annex 4, PC Adams Annex 5. So again, there were several other officers called apart from the key complainants or the witnesses to the initial incident that unfolded. Adams and Goulden were also called because they were witnesses to some of the aftermath. So again, the idea of half a day to a day of trial. Surely the judge wouldn't expect to give a dog a trial within a day, which involves 7 witnesses against that party and an hour and a half of footage. At the conclusion of the case for the respondent, the appellant made a submission of no case to answer. The ruling in note form that was given in response to that is appended hereto as Annex 6. That provides much of the relevant factual backgrounds to this case. Not a single fact is provided at all about anything, not even the mention of my defence that I was the victim of torture, the victim of assault, either on the day or from Chapman or from at the Tesco, the armed assault. Not a single mention of even a vague reference to what my defence was, and he refers to this as facts. Not a single basic stance on the key issues about the perjury, about the squaring up to Gilder, about what the footage showed compared to the statements is mentioned. And the judge says this is a reference to the facts. So here we go on. The appellant made clear that he wished to argue abuse of process. We determined that was best addressed at the conclusion of all the evidence. The Court of Appeal, even if my abuse of process included, it would be torture to make me relive the incident of my being tortured. So he thought that was best leave to whether or not you're going to be psychologically tortured by the trial itself, which also involved me having to relive being CS sprayed and left in cells by Judge Martin Brown. To relive all of that would be mental torture. Well, let's leave all that to after you've been mentally tortured by reliving the trial. The appellant made clear that he wished to argue abuse of process. We determined that the Court of Appeal had given guidance that the stage at when the fairness of trial process can often be best judged is once the court is fully aware of all the evidence and any difficulties that the trial process may have revealed in respect of the party wishing to advance such an argument. Well, no, I mean, certainly these days, if you look at a law book, it indicates clearly that the abuse of process is usually heard before the trial takes place, unless, of course, there's a specific issue that can only be dealt with. But, of course, we've got the witness statements and we've got the footage. So the CPS can respond, Mr. Chidgey, who I'm not going to go down the trial of his response to my abuse of process argument, but all he has to do is examine the footage and look at the witness statements and see that it would be completely illegal to prosecute me because there was no, well, I mean, just on the basis of the no breach of the peace, which I didn't even know about at the time, but didn't think was that important, given considering I can clearly be seen being tortured anyway or mistreated, and clearly the footage proves that the witness statements were utterly fabricated in terms of the squaring up to Gilder, even if the squaring up amounted to a breach of the peace. The appellant gave evidence. My notes of that which he had to say appear at Annex 7. After the appellant had given evidence, 3 further police witnesses were called, Inspector Davey, Sergeant Lewis and PC Denny. The notes of their evidence appears at Annexes 8, 9 and 10 respectively. We issued witness summonses in respect of 2 identified individuals who were in the custody area of Trinity Road Police Station at the same time as the appellant. One of the young men could possibly be heard remarking upon the tightness of the appellant's cuffs. We took the view that as they were likely to be able to give material evidence and the appellant wished to call them, we would accede to his application that they be summoned to court. We did not require the respondent to call them, and neither did we consider that the court itself should call them. This was an issue that took up considerable time at various stages of the proceedings. So what? If it takes up time, why take up more time saying about how much time it takes up? That's completely self-defeating, is it not? In terms of, and how many times has he mentioned about the importance of time in court proceedings? And yet he's willing to take up, untold amount of time, even blathering on about how much time it's taken up, thus contradicting the very point of his concerns about, properly using court time. This was an issue that took up considerable time at various stages of proceedings. We do not set out herein all that was said about that in various exchanges in open court. We could see no possible unfairness in the appellant calling the witnesses himself. In the event it turned out to be the case that one had been incorrectly identified as being present on the occasion in question, the other one, Ty Findlayson, did give evidence, and the note of that which he had to say appears in Annex 11. In relation to the application that I recuse myself continuing with these proceedings, to which reference was made a little earlier, I have set out at Annex 12 the reasons I gave for declining to do so. There was also a stage when the appellant was anxious that the respondent should seek out some CCTV footage relating to a prior contested hearing that took place before another judge in Bristol Crown Court. We declined to require the respondent he means David Chidgey. I mean, he's talking about the CPS. I'm not even sure they were the respondent, but assuming they are, it's very confusing. Because I'm the appellant, and usually, never mind. Anyway, to obtain that material and gave us. We declined to require the respondent to obtain that material and gave reasons why not. Those reasons are set out in Annex 13. There are a variety of other matters about which decisions had to be made during the course of the hearing, but we have not troubled to set out all those in the course of this ruling or by way of creating a specific annex to which reference could be had. They do not seem to us to have the prominence to so justify or require. We now turn to the abuse of process argument advanced by the appellant. The appellant did submit a second skeleton argument to which we paid close attention, as we did to all his oral submissions. I attempted to note all the relevant parts of that which he had to say, and my notes, along with a copy of his skeleton, can be found at Annex 14. We reject the abuse of process argument. We do not accept that the appellant could not have a fair trial, or that it would be unfair to try him. Of course, I didn't know at the time of Judge Picton's relationship to David Chidgey by way of Albion Chambers, which of course I would have raised as my first point of recusal. There has been nothing unfair about the process of this hearing. We are quite sure that the appellant has had more than adequate time and resources to prepare his case. We are quite sure that he has not been disadvantaged by reason of the fact that he is unrepresented. In any event, well, of course, I mean, I was disadvantaged because I didn't even know about the breach of the peace ruling in terms of Laporte v. the Gloucester Police, or the Gloucester Chief Constable of Gloucester Police, because that is the clearly set down ruling that only violence or threatened violence can justify a breach of the peace, and any other form of detention under breach of the peace is unlawful. And of course, if I'd known that, I would have won the case on that basis alone, or certainly built my case on it, And of course, because I wasn't unrepresented, I was clearly disadvantaged. Bearing in mind the judge himself, who clearly would have known about Laporte v. Costa, is remaining silent and keeping that under his hat, knowing therefore that I was being illegally detained and kidnapped by the police rather than lawfully detained, which was, of course, the key, the essence to my defence case. We are quite sure that he has not been disadvantaged by reason of the fact that he is unrepresented. In any event, we cannot change the fact that he is apparently unable to persuade a firm of solicitors to take his case. That could not, in the circumstances of this case, justify staying proceedings against him. He is adept at litigation, and in our view, the appellant knows very well what he is doing and what he is attempting to achieve. The respondents did decide to call fewer witnesses in the course of the appeal than they had previously or could have done. We took the view that the respondent was exercising a legitimate prosecutorial discretion quite properly and fairly. The respondent was not seeking to gain some unfair tactical advantage by doing so. The respondent was simply seeking to retain this case within sensible bounds of court time and resources, and it was an approach with which we fully approved. It was an approach wholly in accordance with the overriding objective. The appellant simply wanted more people to which he could make accusations. He did not in truth perceive P.C. Stenner as having some potential to give evidence that might benefit him, save insofar as the position was covered by the admission the respondent made as reflected in the note of the evidence. The appellant has been given enormous latitude in being able to introduce events concerning other incidents and cases not directly connected to the events of the 8th of April. There is simply no merit whatsoever in the abuse of process argument the appellant sought to advance, and we reject it. So the judge here is ruling, or referring to his earlier ruling, that Karen Stenner, who was the key person that I was supposed to have accused of calling a fucking ugly bitch, which obviously was the most incriminating allegation about my conduct prior to arrest, she wasn't even called to give evidence. The law of the land is clearly that all police officers who were present at the scene should give evidence. I think that's a R.B. Haringey ruling that's been established for a long time. But clearly, if all the other officers were accusing Stenner was stating, well, no, sorry, was some of the officers, obviously contradicted by other officers, but two of the main officers who actually carried out the arrest, Coombs and Hamilton Smith, both alleged I'd called Stenner a fucking ugly bitch. That would have justified an arrest for not breach of the peace, but for a public order matter. So I was being accused of a criminal misconduct towards Miss Stenner on those words. And she herself didn't give evidence to support that allegation. And that was the case on which the whole matter turned in terms of the prosecution case, or certainly that was the most incriminating evidence. And she wasn't supposed to give evidence. So, and she was one of the person that I was accused of. Indeed, the second charge, because it's not clear. It's assumed that the using threatening, assaulting words of behaviour or disorderly behaviour towards with intent to cause P.C. Coombs, P.C. Stenner, and P.C. Hamilton Smith harassment, alarm, and distress. Well, I was focused on the admitted threats of violence to get Coombs at some stage. I was going to stab him or shoot him with a crossbow, which I admitted, when I was being trussed up in the cage, in the context of being kidnapped and assaulted and tortured by these officers. It didn't obviously occur to me that, of course, one of the part of the Section 4A could have been calling Stenner a fucking ugly bitch, or indeed it clearly was, although it wasn't the justification for my arrest. And yet, even though she is a victim or alleged victim in the charge, Judge Picton says that it was all right not to call her. And of course, what's happened is that she doesn't want to give evidence because she knows that she's lying in her teeth, that she knows that I never used those words, and her evidence, the evidence was contradicted all over the place by the CCTV. And so, one of the complainants in Article 6 of the Human Rights Act clearly says that somebody accused is entitled to question those who give evidence against them. And in particular, that would obviously be the one of the complainants. And the judge says even one of the complainants, I can have a fair trial even if one of the complainants isn't going to turn up. We now turn to the appellant's closing submissions. We should mention in passing that the appellant was subject to a time limitation in respect to his addresses in relation to abuse of process and by way of closing speech, 1 hour for each. We took the view that was more than sufficient for him to deal with the matters, and we remain of that view. And it was, so what? I mean, why bother taking up more time and public expense? Bearing in mind these transcripts are themselves have to be paid for, so he's taking up court time in talking about nothing that's of relevance to the guilt or innocence of myself or my counter allegations. Again, while endlessly talking about how much court time the case is using up. In addition to oral submissions, the appellant, a 4-page skeleton. This doesn't even make sense. In addition to oral submissions, the appellant, a 4-page skeleton of his closing remarks plus 2 bundles of other documents. Both bundles were paginated, the first running to 43 pages and the second to 174. The appellant has complained more than once that he does not perceive us as dealing with his arguments. That is a situation brought about by the often discursive nature of them and their lack of true relevance. We are not going to deal with every matters raised in the paperwork to which we have just referred. The appellant's skeleton argument of his closing submissions and the 43 pages of documents attached to that is appended hereto as part of Annex 15, which commences with my notes of his oral submissions as per 3rd of March. We have decided that it is not necessary to copy the 175-page bundle. In setting out our conclusions on the merits of this appeal, we will identify only those findings that we need to make to resolve this case, as opposed to addressing every issue the appellant has sought to introduce. God knows what all that is all about. It's he's already said at least twice that a lot of what I've tried to rely on is immaterial. In his view, is not relevant. Although we don't even know even the most basic form what my other allegations were or issues raised. So why does he have to keep repeating it over and over again? Because it's soaking up time and energy, and anybody that would be interested in this case, by the time they actually get to the substance of what the issues are in the case, he still hasn't got to even remotely what the issues were that needed to be decided, and we're 4 pages into the judgment. So we finally get to the conclusion where this is when he finally, as promised, he's been keeping us on tenterhooks about actually what this case is about, and this is when he claims to be doing it. Conclusion. We reject this appeal for the following reasons. 1. We are sure that on the 8th of April, the appellant went to the police station intent on generating a situation of conflict. He was, for reasons only he can know, set upon seeking to provoke the police into arresting him. The appellant did not tell the truth about his reasons for being at the police station on this occasion. He was not genuinely motivated by way of seeking their help. He just wanted to make trouble and wanted to get himself arrested. We found the evidence that the appellant gave and the manner in which he gave it enlightening in that regard. Well, on what basis has he said that there is evidence that I deliberately wanted to get myself arrested for its own sake? This is what he's finding. In order for him to find that, he would have to have evidence from me stating I deliberately went. I wasn't interested in the fact that Gavin Manley and certainly Mr. Chapman were loitering in the doorway of the court building in which I had to attend, because he was and I didn't want to attend whilst he was there without police supervision, because he was under criminal investigation by PC David Townsend for assaulting me. There's no mention of the PC David Townsend letter, which was obviously produced and canvassed by the judge and part of the bundle of paperwork that I'm complaining the judge is refusing to refer to. He's ignoring the letter, the ongoing investigation. He's ignoring evidence even given, certainly by PC Stenner, so that's presumably another reason why Chidgey and Picton didn't want Stenner to turn up, because she is the only witness to the incident, or she was involved in the actual incident of February at the Magistrates' Court, in which I alleged to have been assaulted by certainly Mr. Chapman. And Mr. Manley. of which footage was disclosed. I indeed had to relive the ordeal of February because the judge allowed me to show the footage of my being twisted up, and then of course completely whitewashes it, and then states there is evidence that's been put before him that, never mind the ongoing criminal investigation into Chapman's conduct, that was formally addressed by David Townsend. None, even reference to my complaint that there was no police officer present at the building, that I'd turned up once, no dispute that I'd gone back to the court and having been promised that police would be attending when they didn't attend, then went back a second time, and then simply fabricated that there was some evidence, although he doesn't actually refer to any, that this had nothing to do with my attendance. I simply enjoy having police put their hands on me and molest me and inflict great pain on me. He's effectively accusing me of being a sadomasochist, or indeed a masochist. Never mind the sado, because I certainly haven't. The only kick was clearly in self-defense, but or let's say sadomasochistic. I don't know, but he's accusing me without any evidence of getting off, of simply of being arrested, including even if I enjoy being arrested in some sadistic, twisted mind of Judge Picton, because that's probably more his bag. That's probably because a lot of these judges are into all kinds of vileness. You look at my documentary Barbarians at the Gate, in which we have glaring evidence that His Lordship Judge Adrian Fulford is certainly very partial to paedophiles and has close connection to paedophile Tom O'Carroll, whilst Tom O'Carroll was known to be a paedophile at the time. We hear about these stories of judges who go and attend, all kinds of dodgy kind of. But anyway, I mean that must be the mindset of Martin Picton. If without any evidence, he thinks that there are people in this world that simply enjoy getting arrested. And if I did, why would I be complaining? Why would I be appealing? Why wouldn't I be, there and then getting myself twisted up by the police or the court security staff? If it's simply pleasurable, why was I even appealing it? I could have gone to prison, and you've only got to blink at a prison officer and you get twisted up every which way. So he's saying for reasons that only I could understand. Well, if it's only reasons that only I could understand, then he has no evidence, because I haven't given him any evidence that that there was some alternative to my getting myself arrested. It is absolutely true that my position is, because I'm subject to, as I've explained, I think in my first documentary, but in certainly other documentaries, I'm subject to have been subject to a general civil restraint order, which means that I cannot litigate, which means that any form of abuse or any violence, whether it's ongoing, as it was with Chapman on that occasion, or any form of situation from my neighbours in Boswell Street or wherever, if I can't litigate, I cannot get legal representation. Judge Martin Picton himself referred to the fact that he seemed to accept that I couldn't get legal representation through my own steam, even in criminal defence, let alone litigating against other wrongdoers against me. So if I can't get representation, can't get access to the courts under my own steam. This is what I get if I do try and represent myself. I'll be in chambers, I'll be in chambers left, right and centre, all with the same vendetta, all with absolutely the same script as to blaming me for everything, scapegoating me, and lying and colluding and lying as their way to convict me or dismiss allegations that I've made against others. But at the end of the day, that is the essence of protesting. Is if you get yourself arrested, then you get some kind of justice. You get some judicial oversight. Of course, if I had known that it was going to go before Martin Picton and Judge and Mr. David Chidgey, who's now himself a recorder, sits as a judge. Of course, I probably wouldn't have bothered getting myself arrested. I would have known that it would have been a stitch up all the way through to the lying crook Judge Silber and his renter judge for the day, Mr. Chinweizi, who himself has now become a judge. And another point I make is that anybody that is involved with blood on their hands, who is involved in this kind of villainy, gets promoted because they're in the right camp. They're in Albion Chambers camp, and Albion Chambers are a bunch of crooked, lying gangsters. That is their essence. That is what they do. They live and breathe gangsterism, and there's nothing they won't stop at. And I hope that if I can't prove this by way of the case against Judge Martin Picton, I will never be able to prove it. But in any event, it's clear that my case was that I had no other choice but to risk and endure being arrested, not, of course, on the understanding that I was going to be twisted up by and had the handcuffs put on tightly and all the rest of it, but I was at the end of my tether, because I was either going to get done for not attending the court, or I would have to be risk being assaulted by Chapman. So I had no other choice but to attend the police station. And what was I asking? Nothing more or less than simply having any officers that were already presumably present at the Bristol Magistrates Court, just to keep an eye on things between myself and Chapman when I came in and out of the court building. 2 minutes of their time led to tens and tens of thousands of pounds and all this unfolding. But anyway, and we'll carry on. So, point 2. We are sure that the police officers who dealt with the appellant did so in a properly restrained and wholly professional manner. P.C. Coombs maintained his self-control throughout, despite being subject of the most vile provocation. Every effort was made to avoid arresting the appellant, but he was determined to create a situation where one or other officer was forced to do so, and in that he was successful. Well, what vile provocation? The only form of provocation that was, or the only evidence of wrongdoing that was presented, was my allegedly poking my finger and calling Mrs. Stenner and calling Karen Stenner, I don't want to call her Mrs., calling Karen Stenner a fucking ugly bitch. That was not very nice. It's a bit abusive, but there's hardly the most vile provocation. And in any event, officers aren't supposed to arrest because of vile provocation. And if they're being professional, they don't arrest at all unless someone is committing a breach of the peace or some other criminal offence. And even if they are committing such offences, the arrest has to be proportionate and the use of force has to be proportionate. But in any event, this judge gives no indication of what vile provocation I offered, and indeed what was the justification for my original arrest. Of course, the fact that I threatened to kill him and shoot him with a crossbow, that would be vile provocation. But that was after my arrest, and that was when I was already trussed up in a police van after I was covered in injuries from these officers. So it clearly had nothing to do with why I was actually arrested in the first place. The respondent correctly sets out the legal position in the skeleton dated the 18th skeleton argument, that's short for, dated the 18th of October 2010 at paragraph 2 to 9. We are quite sure that P.C. Coombs had reasonable grounds to believe that it was necessary to arrest the appellant to prevent a further, brackets, breach of the peace. That is a well-known and well-recognised common law power vested in a police officer. It is an assessment and decision, and police officers often. It is an assessment and decision, and police officer often has to. So again, appalling English. Police officers, it presumably means, often have to make in a highly charged and stressful situation, as was the case here. Well, all the stressful was the cause of the police. All I needed was a police officer, at the risk of repetition, to be attending while the man being investigated for criminal assault was not able to contact me during my egress and entrance in and out of the court building. That was the stress was all the police, and even the looming over. Judge Martin Picton doesn't give me any indication about their body language. They're looming over me. I'm face to face with the groins, which I really don't want to have to be face to face with. If you are trying to de-escalate a situation and not lead it to that person having to be arrested, you don't loom over them and shove your groins in their faces when you're doing it. You sit down at equal eye level with them, preferably sit down, or allow them to stand. But anyway, the footage speaks for itself, and I will be showing it obviously as I read this out, as this is when this matter is finally put together. The power, there's no dispute that powers have arrested breach of the peace. They have powers to shoot somebody. The issue that the judge has to assess is not whether they do have the powers to do that, but whether the powers are being lawfully deployed in the given situation, which obviously needs to rely on the evidence supporting the particular sides of the parties in the case. There's no dispute. It was never argued by me that police don't have the power. Indeed, not only police, but civilians have the power to arrest people for breach of the peace. The issue is what constitutes a breach of the peace to allow such powers to be used. Given the power is excessive, it's depriving people of their liberty. It's the worst power, short of killing them, that you can have over somebody, taking away their liberty. In essence, the key words here finally got to nearly 6 pages into the judgment. P.C. Coombs rightly perceived himself to have a power of arrest and lawfully exercised that power. The appellant was subject to a lawful arrest and thus properly detained. Well, what is the law? We don't know. We don't know if the judge knows. He just says it was lawful. So he's effectively, he might as well have been there in the room and said, arrest this man. It's lawful. I give you permission to arrest him. And when it comes, when the key issue, the only thing that really matters to these whole proceedings is whether the arrest was lawful, because then that, and obviously whether it was proportionate, but the main issue is the lawfulness of the arrest without any reference to the law whatsoever. The law is here on the screen. It is Laporte v. the Chief Constable of Gloucester Police. It is a clear-cut, cut and dried. It has to, it's founded, the essence is founded on violence or threatened violence. And nothing in P.C. Coombs' statement suggests even remotely violence from me. And indeed, even the judge whitewashes and ignores the fact that Coombs had already restrained me. He'd already used force long before even he himself claimed to have arrested me, when he put his hand on my chest and I had to force my way through him to get out. And the judge is accusing me of deliberately stirring things up to get arrested, when I can't even move away from Coombs and I have to use force to push him, to push against him pushing me, preventing my leaving at all, even when he himself has not claimed to have arrested me. The judge goes on. P.C. Coombs' application of cuffs was lawful, proportionate and reasonable. Proportionate and reasonable to what? The fact, all the judge has indicated is that I've given some I've deliberately got myself arrested. I provoked the police into arresting me, which is not a breach of the peace. It is not violence. And so therefore the arrest is clearly, if the arrest isn't lawful, it can't possibly be proportionate to manacle me at all. But why is it? Why is the use of handcuffs lawful or necessary? Because I'm being provocative. Surely the handcuffs are there if there's issues of violence or threatened violence. But again, because there was no threat of violence, that doesn't even justify the arrest, let alone the use of handcuffs. In reality, it was inevitable, given the way in which the appellant was determined to behave. But what is my behaviour, Judge Picton? Can you just give you some tiny indication? You can't hear what's being said, so you can't verify whether I said fucking ugly bitch. You haven't mentioned the allegation of fucking ugly bitch that was being levelled in your reasons for the arrest. In reality, we accept the evidence given that the application of cuffs was subject to the fingertip test, i.e. that P.C. Coombs and Hamilton Smith checked the cuffs were not too tight. Well, they're reliable witnesses, aren't they, given they're the ones who are applying the cuffs. But anyway, the injuries that the appellant sustained to his wrists were the result of contact between his wrists and the cuffs, but that was not because they were too tight. The fact that Mr. Finlayson noticed the appellant's hands to be red when at Trinity Road Police Station and thus perceived that the cuffs were too tight was not because they were too tight, but because of the appellant's own behaviour after they were applied. All the injuries were consistent with the respondent's witness's description of how the appellant conducted himself after the cuffs were applied. The appellant caused his own injuries. He was not tortured by anyone. The appellant was not defending himself when he kicked P.C. Coombs. Well, just momentarily there on Mr. Finlayson. Well, after all this trouble that the court and the staff and the public taxpayers had to go through to finally get Finlayson to the court, as even the judge indicated the problems they had in getting him to give evidence. He gave evidence, and this is interesting, in terms of my general allegation that Judge Picton, among other things, is a child abuser, and of course I'll come on to that in terms of the Tesco incident in a minute. But Finlayson himself was a kid. He was, I don't know, 10 or 11 or 12, 13. I didn't get his exact age, bearing in mind he had aged since the actual incident by a year or so. But he gave evidence that he himself had been cuffed by the police, and he knows he could recognise from the way I was cuffed about his own cuffing. So apart from anything else, he's given evidence that the police torture him as well, because when he's arrested, and I don't make any comment on whether he was lawfully arrested or not. But he's given some evidence that he was being tortured by the police in terms of how the cuffs were used, which is how he knew the cuffs were too tight on me, and he should know better than Judge Picton, because Judge Picton, of course, has no risk that he can go through his life, and even if he does come to be arrested, as he should be, he's not going to be twisted up and in the way that I was. Of course, in many cases, most people are going to go in front of a jury. So if the arrest is overly brutal, that they immediately lose. And certainly, if that person's got a decent enough barrister, that person is going to lose. The police lose credibility in the eyes of the jury, and indeed they could still face prosecution and or being sued for unreasonable force, even if the arrest is justified. So obviously what they're doing in my case is they know all bases are covered. I can't get representation, and they're going to get the evil gangster cronies from Albion Chambers to take it up. Indeed, I suggest that they'd already, because of my reputation by now, by the time I'm arrested in April 2010, I'm already well known to Albion Chambers. As I say, I've already won 2 trials myself, which I'm not even allowed to disclose because of orders from another Albion Chambers judge and barrister, or now who himself is now a judge, so can't go down that path. But I'm well known now as a campaigner, as somebody that thinks that something really stinks at the heart of the Bristol judiciary establishment, and the way they're hand in glove with the worst elements of the police force. And it's almost certain that they are just trying to just absolutely put the moves on me to suppress me, to terrorise me, because they don't want me running around Bristol with the evidence I've got that they're corrupt, that they're as corrupt and evil and colluding in all manner of things, including, of course, as we'll come to in a moment, the child abuse that I've referred to. But for instance, he of course, Judge Picton whitewashes the key evidence wasn't that he just saw red, but that he recognised the cuffs were too tight because he himself had experienced too tight cuffs. He's a gentleman of colour. I don't know if I mentioned that, of course. And it would be arguable that was evidence of police racism as well. But the judge, not only was there evidence in my favour, so the judge is going to whitewash it for that reason alone, but it's also evidence in its own right that Finlayson himself was subject to police abuse, especially given that he was already a minor when he was referring to the use of the cuffs in this way. So we come on to number 5. The appellant was not defending himself when he kicked PC Coombs. We are quite sure that PC Coombs was treating the appellant entirely properly as he attempted to remove him from the foyer of the police station. Well, why did he need to remove me from the foyer? I'm in cuffs. I'm trying to speak momentarily, just to even. We've got the evidence from, among other people, Tina Brewer herself, that no reason that she could understand was given as to why I was arrested at the time. So I'm not even allowed to consult with Gilda, the senior officer present, as to why I've been arrested or make any kind of representations. There's suddenly an urgency. Now I've been restrained for me to be out of the door. And the way that happens, according to Judge Martin Picton, is perfectly reasonable, to twist the cuffs and use the pain and the force and the indignity as a way of propelling me forward, without even giving me a second to catch my breath, having been arrested. As I say, I mean, from my point of view, I would not treat my worst enemy. If, as I hope, in the fullness of time, Picton is arrested for misfeasance, i.e. misconduct in judicial or public office, as he well should be, as part of his fall from grace and power, I wouldn't want him to be arrested even if it would, and not just because it would obviously affect the fairness of the trial and potentially lead to him claiming to be the victim. There's no need to treat human beings in the way that Coombs is treating me, even if my arrest was justified. Bearing in mind, we don't have a clue so far from Judge Picton as to why I've been arrested, other than vague reference to my wanting to be arrested and provoking a situation for my being arrested, which doesn't even have to be lawful. I mean, no police officer is going to say, I arrested him because he provoked it, or he wanted to be arrested. That wouldn't be a lawful arrest. The judge has said that it's lawful under the breach of peace powers, but he hasn't said what is a justified arrest under breach of the powers, which is a common law, which is set down in stone as to what it has to be, violence or actual violence. And so we don't even know whether it's predicated on violence or actual violence, because the judge has whitewashed that. And even if it is, and even if he did refer to it, what evidence have the police given that I've been violent or threatened violence? He did not twist the cuffs. Well, we can see him twisting the cuffs. There's no way that I'm just happen to be deciding. I'm no longer going to speak to Reginald Gilder as I'm clearly intending to do at the first part of this scene, and then I suddenly, with one motion, just as Coombs decides that he's going towards the door, I just happen to go follow in that direction. It's not as if the judge is credibly saying that the only reason I'm moving away from Gilder and facing in another direction and suddenly going at a fast pace, being frog marched, to use the military expression that these police officers love, being frog marched out of the front gates, the front sliding doors. So the only way I'm moving in that direction is because I'm being steered, because Coombs is twisting the cuffs. Any other alternative is clearly a bold-faced lie. But this judge, there's no lie. This judge, I'm surprised he didn't convict me of armed robbery in the bargain and give me 20 years. Why bother? Why bother going to such lengths to embark on such ludicrous lies over something so petty? I mean, what difference does it make? All that would have happened, all that did happen, indeed, was that I spend a few weeks in prison watching television, waiting, biding my time to get out, lodging my appeal, which is obviously going to cost the taxpayer even more money. The only reason is, obviously, we've established that the Albion Chambers conspiracy to shut up Ben Gray at all costs is the main motive. But obviously, because I'm being arrested so many times without conviction, especially when I'm receiving injuries, they have to get a conviction. Otherwise, it just looks like, straight out of Nazi Germany, and it becomes untenable. So that they have to, certainly, as I've been convicted anyway by Judge Martin Brown, albeit I was being burnt alive in cells, then especially with that conviction, if it's overturned, it's just how it reflects on the CPS and on the police generally, that's another reason to get a conviction at all costs, rigging the judge and the barrister to all the way through to having a judge that just lies and lies and lies and lies about the most, it's petty in terms of trying to get me convicted for relatively petty, everyday kind of charges, such as assaulting police, which happens, several times a day, unfortunately. But to get a conviction for such a petty matter, but in order to get the conviction, having to collude in the most brazen and most serious criminal offences on the books, such as perverting justice, perjury, torture, and so forth. And I should just point out, of course, in terms of torture, this judge has clearly, by making me relive every single bit of violence and then whitewashing it, any mention of it on the judgment, even my most basic allegations, let alone the evidence, both in the instance of the 8th of April, the incident on the 19th of February 2010, the incident at Tesco's, all of which I've had to relive. He's torturing me. He's committing, by any criteria, mental torture. And he's himself committing an offence under Section 134 of the Criminal Justice Act 1980, I think it is. Come up on the screen. Any public official who tortures a member of a British subject, a British civilian, is committing the offence of torture. And this judge is a torturer. Apart from being a liar, apart from perverting justice, apart from colluding in torture by others, he himself is engaging in the most vile torture. But anyway, we'll carry on. He did not apply anything that could be described as unlawful or excessive force. The appellant kicked PC Coombs because he wanted to. He did so out of anger and spite. Sorry, I have to laugh, because if I didn't laugh, I would scream and cry. We are sure self-defence did not feature. Contrary to the appellant's understanding of Section 76 of the Criminal Justice and Immigration Act 2008, has not changed the law on self-defence in any way that affects the decision in this case. It is for the prosecution to disprove self-defence. In our view, they have. The appellant did not believe himself to be entitled to act as he did, and neither did he believe that it was necessary. It was gratuitous and deliberate violence on the part of the appellant. I mean, we can see the extent to which I'm doubled up. I'm literally being brought to the floor. I'm having to walk in an odd fashion because of the downward pressure Coombs is applying to the cuffs. And we've also got the injuries from the cuffs. We reject the appellant's suggestion that he felt that he was subject to duress so as to justify kicking PC Coombs or later uttering the threats that we are sure he did. The appellant was acting on this occasion in a manner deliberately designed to provoke his own arrest. We did not believe his evidence. The appellant's apparent obsession with his previous conflicts with the police and courts make colour his judgment. That he means may colour his judgment. He has not even gone through the most basic spelling mistakes in the judgment that is depriving me of my liberty and addressing the most serious matters it was possible to imagine. His judgment, but it is not anything that could remotely be likened to something that could be described as duress. Accordingly, we are sure that the appellant did assault PC Coombs in the execution of his duty. We are also sure that the appellant uttered threats of the kind that can be heard on the CCTV recording of the custody area and Trinity Road, both in the van on the way there as well as at New Bridewell. They are vile and repulsive threats. They were such as would cause anyone hearing them harassment, alarm, or distress, and in fact did cause PC Coombs to so feel. The words, so, on reflection, of course, some of the Section 4A charge must have related to my allegedly calling PC Stella a fucking ugly bitch, because obviously I wasn't with Stena when I was making these threats, and they were specifically made towards Coombs, as indeed the judge himself has made clear. They are designed to be. There was no element of self-defence in the uttering of them. The appellant cannot claim duress for the reasons we have explained. While some officers did not hear or note the words used, others did, and their evidence we prefer and are sure of. PC Coombs was a wholly honest and reliable witness. Even the appellant struggled to deny the use of the words with any true conviction. Accordingly, we are quite sure that he is guilty of that offence also. I don't think I did deny it. I think I denied the words used when I was in at the police station, but I didn't deny when I was in the van or at Still Trust up at Trinity Road Police Station. We'll finish off with the finding that PC Coombs was a wholly credible witness. Well, we know about his statement that I was squaring up to PC Gilder, and we can clearly see on the footage that I did not square up to PC Gilder. The only vague reference to the grounds of arresting me or the decision to arrest me is clearly predicated both by Hamilton Smith and Coombs, the arresting officers, on the allegation that I had squared up to PS Gilder. And we can see as clear as day that I do not square up to PS Gilder. PS Gilder moves, at the risk of repetition, he moves himself voluntarily towards me and puts his hand on my chest, even assuming there had been a decision to arrest me, which there hasn't. And he himself does not say I was arrested. I tried to square up to him. I was arrested for being obnoxious and for shouting. And the only person that could have verified whether or not I said fucking ugly bitch, indeed he himself doesn't say that I used the F word in front of him. And the only person that, Miss Brewer doesn't indicate that I used the F word or bitch prior to my being arrested. But Coombs is lying in his teeth. All we need to know is that he's lying in his teeth about squaring up to Gilder, given that he gives that as the reason for arresting me. And we know, therefore, that it is not Coombs who was an honest, reliable witness. It is this man, Judge Martin Picton, together with his Albion Chambers crony mate, David Chidgey, who is not reliable, who is not honest, who is a complete and utter crook. And by any criteria, he himself should be facing charges. There can be no doubt, surely, in anybody's mind that's watched this video, that's looked at this evidence, all of which is in recorded proceedings, so there can be no dispute about every single statement and every single finding the judge has made and every piece of evidence that was relied on, that judges, that he is guilty, that there's prima facie evidence for which he should face himself prosecution for misconduct in judicial or public office, in line with the common law of R.V. Bembridge and R.V. Llewellyn-Jones, where judges have been found guilty for misconduct in their office as judges and been sent down. And this is what this judge should be facing, not just for my sake, not for justice, just for me, or any of the innocent parties involved in the cases. Of course, we've had no mention of the Tesco incident. Indeed, Reginald Gilder moaned and complained to the extent that the judge deliberately sidelined that finding when it was clear bad character, and there was clear ruling under bad character about that. But for the sake of, not just for the sake of all the innocent parties who were victim in that missile attack, in which Judge Martin Picton was clearly colluding, because clearly if he had any evidence that Power's report was a whitewash and lie and fabricated and perverting justice. Indeed, that became more obvious as Gilder himself gave evidence that he's also colluding in that matter. But of course, how can the justice system have any credibility and have any merit at all before the public if judges can simply lie on this kind of scale to cover up this kind of wrongdoing? And of course, with that in mind, I tried to judicially review the decision of Judge Picton before the High Court in London at the Royal Courts of Justice, and this went before Mr. Justice Silber. Mr. Justice Silber responded with the following, and it's very brief, so it won't take up much of your time, and he states this. 1. Permission is hereby refused. The permission for judicial review is totally without merit. The costs of preparing the acknowledgement of service are to be paid by the claimant to the Avon and Somerset Constabulary in the sum of £332 unless within 14 days the claimant notifies the court and the defendant in writing that he objects to paying costs, or as to the amount to be paid, in either case giving reasons. If he does so, the defendant has a further 14 days to respond to both the court and the claimant the right to reply with a further 7 days, after which the claim for costs is to be put before a judge to be determined on the papers. A civil restraint order should be made in terms of the attached. The claimant's application of 23rd of February 2012 in relation to contempt should be heard by a High Court judge as soon as possible. Well, I never got the hearing 23rd of February, I don't think, but you can see here the judge he's saying that the application before him, that the grounds, that all of which are just a replica or a version very similar to the ones that I've given in the documentaries, the first and second part of this documentary, and he says that I should be subject to a restraint order preventing me further litigating, because this is evidence that I'm a vexatious litigant and I make wild allegations that are unfounded and are totally without merit, as he said. And he makes these observations, that these are the reasons for that decision. This application was not brought within the prescribed 3-month period or made promptly. The claimant was entitled to and should have made an application to the appropriate judge for permission to make the present application for permission during the currency of the restraint order. So permission must be refused on that ground, as granting the claimant permission to pursue this claim would prejudice the rights of witnesses to have finality to these criminal proceedings and would be detrimental to the good administration. Well, all of that is largely irrelevant if the judge is correct in saying that the case was, my application was without merit, and of course that's what we deal with in the second point. But of course he complains that I'm out of time because I was subject to a general civil restraint order until that time elapsed, in which case I made this application. So and he says that I should have made the application for permission to permission, but I can't afford it. The application for permission, which is a bit of a mouthful in and of itself, for people that are on benefits and normally be entitled to fees exempt and not have to pay any money for applications, as I would be because I was on benefits, don't apply to people who are subject to the general civil restraint order. So if you're rich and you're subject to a general civil restraint order, that's nothing. You just make the application because you can afford to pay for the permission. I think it's about £55. But of course, if you're me and you're on benefits whereby £55 would be a third of your monthly income, you clearly cannot afford to pay for permission. And even if you do make the application, all you do is you get a liar like Judge Silber, who will simply lie to say the case is without merit anyway. So you just wasted the £55 because obviously this was paid for by the taxpayer. So it's the taxpayer's money effectively Silber's wasting, although he imposed the costs on me, which I don't think were ever sought anyway. But the second reason is far more important, because this is where he actually claims to provide some reasoning for saying that the case is without merit, me having relied on film footage, witness statements and the judgment that we've read out. of Picton. In any event, permission would have been refused because A, of the reasons set out in the Crown Prosecution Service's grounds for contesting the claim and in particular paragraphs 17 to 32 thereof, and B, the claimant had an alternative remedy available to him, namely appealing by way of case stated in respect to many of his complaints, with the consequence that permission should be granted. Well, there's no suggestion there that the judge has examined any of my grounds. We don't know whether he even knows what my grounds are. And this is another issue in terms of the wide open availability of corruption certainly in the Royal Courts of Justice, or any case where there's not automatically a hearing, because by the time you've made your application, it's gone through 3 or 4 caseworkers, most of whom aren't even lawyers, or all of whom aren't lawyers, and many of them don't mind the odd bob coming their way from any source. But in any event, and certainly know which side their bread is buttered, which is on the side of the CPS in my case, and the police in my case, and Judge Picton in my case, and not on the side of some dull scrounging person who's now got convictions thanks to the grounds of the nature of the application being made. So by the time it's reached some judge who's got a pile of documents that he's supposed to wade through, when these are judges, the High Court judges will have, they're dealt with cases on the paper in the first instance, or a lot of the applications, such as permission for judicial review. So they will have a bundle, as high as the ceiling. And by the time the judge has got to look at the paperwork, nobody, the applicant especially, has no idea what the judge is actually seeing. The staff could have easily replaced it with some other document, certainly if they know that person's unrepresented and there's no way of checking. So the only way around that is for the judge to ensure that there's been no foul play, and the judge is getting the documents that were put before the original application, is for the judge to indicate in the decision, especially if it's on paper and it's a final decision, that he has seen, he or she, but I'll say he for shorthand, has seen the actual documents that are being relied on, and the grounds are properly set out as relied on, or not properly set out, depending if they're not, who the applicant is. But if they don't cite what they understand the application to be, or what evidence has been relied on, then there's no evidence at all the judge has seen. Just as in this case, the judge has actually seen what the application consists of and what the evidence was. He certainly hasn't said, I've looked at the footage and it doesn't, like Picton says, although Picton doesn't specifically say what's in the footage at all, whether it agrees with the claimant's version or the respondent's version. And the only way to attest that is the footage. The idea, the reference to by way of case stated, that's only on points of law. So if there's a key ground which I probably could have made, presumably from the magistrate's court, such as that it was illegal to try me whilst I was covered in CS spray in the cell. That was one alternative, but I couldn't because I was subject to the general civil restraint order that the judge refers to. He knows full well that I couldn't make a case statement because I'm subject to the general civil restraint order, which is already referred to as part of his decision-making process. So the fact that I couldn't make a no case to answer application, in fact, cost the taxpayer, even if you don't care about any of the lies and the necessity for this matter to go before a trial, because even if me as defendant, because there's evidence that I'm not the victim and the police are the culprits and the CPS, all of the money that's gone into that is because I was being called a vexatious litigant and I was unable to make a very brief no case to a case statement. An application for judicial review by way of case statement to say that it was, that just on the bare face of it, it was a legal trial because I was covered in CS spray, as it turned out, an innocently accused of assaulting the security guards, when in fact I was the victim of torture and an illegal assault via the CS spraying. And indeed, Judge Martin Brown, who was also a witness in the case, was interfering with the investigation into the fact that I was the victim of the assault by carrying on with the trial rather than allow the incident that had unfolded at the magistrate's court to be properly investigated. So he was perverting justice and giving me an illegal trial. That obviously only an utter barbarian would have dismissed that application, but I couldn't make that application because not only was I not represented, but because I was subject to a general civil restraint order and I couldn't afford to pay the permission up front. And in any event, I was totally entitled to make a judicial review because that is the purpose of judicial review. It's to judicial review the legal conduct of the lower court. The Bristol Crown Court was lower to the High Court. The High Court had a moral and legal duty to investigate any allegations the trial was illegal and that there was perjury and perverting justice as part of the proceedings that were relied on. And indeed, Judge Picton just simply lied hand over fist and didn't even bother referring to any of the key evidence in the case, such as the CCTV footage, such as the medical injuries, or such as even what the alleged conduct was that led to my being arrested. And so forth. But even when I did make that application and it did go before a judge, once the general civil restraint order preventing my litigating had expired, he whitewashes it anyway, which is what would have happened if I'd actually made a no case to answer. So the corruption that's bound up within itself is just beyond belief. And indeed, of course, my main complaints about judges being held accountable for misconduct in public or judicial or public office. My point is that how do you get a judge investigated for such misconduct? Well, only if they refer. If in the case of Judge Silber, the only way he could have been prosecuted for his own misconduct and colluding in the torture and the perjury and the so forth from Judge Picton is if he had handed himself into the police and said, I'm a corrupt judge and I've committed misconduct in judicial or public office, because he's the only judge, he's the only High Court judge that will see this case, or it has been until it's been put before Lord Justice William Davis, who's made the even more draconian civil proceedings order. And you have to go to another documentary to read and see all about that. But turkeys don't vote for Christmases, and judges, High Court judges who are on $250,000 a year, don't suddenly hand themselves into the police after an attack of conscience and says I've engaged in misconduct in public office. And of course, the press, we saw what the press did with the assault even when I was CS sprayed, I was gassed. I was apparently the assailant, even though there'd been no trial or hadn't even been charged, and I was already, according to the Bristol Post, the assailant. This is what you get with the press in terms of the kind of pressure judges are under not to engage in misconduct in public office, because the press are as corrupt as the corrupt judges that are supposed to be overseeing the press, who are themselves are supposed to be overseeing the judges. Very finally, therefore, we saw that Judge Silber relies on the response of one Leslie Chinwezi, and Chinwezi is was at the time a solicitor who worked for the CPS, so he's hardly independent. He's not even a barrister from another chambers who could look independently at the case as a whole. He's from the organisation that is being litigated in terms of the application for judicial review, and obviously he's going to say anything. He can say anything he likes, because the judge he's not going to assess the merits of the case himself. He's going to delegate it to one of the parties, who's not even an independent barrister, but from the actual organisation that's being litigated, which itself is a monstrous joke, self-evidently. The judge is supposed to be by law independent and impartial. He's not supposed to be batting for any side. He's supposed to be taking an overview and applying his own independent position on what the application merits are or what the response is, and which is correct. He can't do that if he's simply relying wholly 100% as part of his judgment on the decision, and not even saying why he's relying on it, i.e. in terms of having any independent input himself. But reading not going through the whole document provided in defence from Mr. Chinwezi, or Judge Chinwezi as he now is, so presumably he's supposed to be called the Honourable Chinwezi, but I don't think he is, as we shall see in a moment. He states, under the paragraph summary of the claimant's grounds, Mr. Chinwezi states as follows: in the event that the court is prepared to consider the claimant's grounds, notwithstanding the time which has elapsed from the decision of the Crown Court, his grounds can be summarised as follows. Firstly, that the rehearing before Bristol Crown Court was unlawful in that 1. HHJ Picton refused to recuse himself despite the fact that he had knowledge of the claimant's antecedents, H.J. Picton, well, I didn't mention that in all the other matters that needed to be raised earlier on in the documentary, but obviously that was a further point, that of course he would have known about all my antecedents. He's supposed to be a jury. Juries aren't supposed to know about a person's bad character unless permission has been given by the judge. So ordinarily, where it's summary proceedings, i.e. where the judge is also the jury, and obviously beggars belief we still have such a system in this country, but obviously it will be looked at it should be looked at by a separate judge, and the judge will decide, you know, what evidence should be allowed, what bad character should be allowed in terms of both sides, because of course I've got the bad character, for instance, of Gilder, for example, and so there's an independent judge. So the judge who finally gets to hear the case doesn't know anything further about the case. But it was a minor matter given the context of everything else that I've raised. H.H. Picton refused to summons witnesses on behalf of the claimant. Well, he didn't have to summons Karen Stenner. He had a choice between stopping the case and summoning her, but he had to do both. That is the clear ruling of the High Court in terms of police witnesses to the incident in the case. They should either stay the case or call the witnesses under the powers that courts have to call witnesses. H.J. Picton ruled that the bad character in relation to P.S. Gilder was irrelevant. The court failed to give adequate reasons for its refusal of the claimant's appeal. The court ignored CCTV evidence of the assault on the claimant by Mr. Chapman at the Magistrates' Court. The court incorrectly ruled that the claimant had caused a breach of the peace. So by this time, I did have some familiarity with the breach of the peace ruling. He did. I don't think. I mean, you can replay it, the judgment of Picton, but I don't think he did actually say that I had caused a breach of the peace. He just said that the arrest was lawful, so it was implied that a breach of the peace had occurred. The court ignored CCTV from New Browell Police Station demonstrating the claimant was justified in acting in self-defence. Secondly, that witness P.C. Coombs and P.S. Gilder had committed perjury, and the judge H.H. Picton had colluded in this offence. Well, yes, so he does actually refer to that claim, but that comes under 7, and it's not a separate point. But in that he's dealing with it as a separate point, that's fine. He does cite the allegation, and we'll come on to how Mr. Chinwezi responds to them. Claimant's antecedents. Well, I'm not going to ignore the antecedents because that's neither here nor there. I do have a bad character. I have got previous convictions, but they're all made in the same kind of vein as the convictions that we're dealing with here. So unless we go into each case, obviously we deal with cases with more recent convictions, which is dealt with by Barbarians at the Gate. But in terms of historically, I would have to go through provide instance the evidence for all the other cases. But let's not rely on that as a defence. It's hardly relevant considering the far more serious counter allegations and grounds of my judicial review application. The same applies to the non-bad character of P.S. Gilder, except of course P.S. Gilder is far more relevant because P.S. Gilder would have a motive. He's got a vendetta because I've got him in trouble. And prove that he's a corrupt police officer because he even got told off by an infinitely more corrupt Powers, given that Powers engages in far more of lies and perverting justice surrounding the disposal of the evidence of the missile that was thrown, of the CCTV that was never seized, and so forth. He blamed it all on me, according to Mr. Katnos, who wasn't even, he said that I was the aggressor when Katnos wasn't even witness to the incident. Well, certainly the initial stages of the incident. So Chinwezi says that in terms of P.S. Gilder's bad character, it is submitted that the bad character of P.S. Gilder was irrelevant to the claimant's case. A report by Inspector Power on behalf of the Police Professional Standards dated 1st of October 2008 confirmed that P.S. Gilder should be given words of advice over his failure to complete a crime report in respect to an allegation of assault made by the claimant. However, given the claimant's unreliability and independent evidence describing him as being the aggressor, the report concluded that even if P.S. Gilder had recorded the allegation, no further action would have been taken. So Chinwezi he's made it very clear that he's well aware of Inspector Power's report. He's obviously read it because he's referring to what Power's findings were, dismissing the report beyond the mere words of advice against Gilder. So my complaint was that the report itself was utter fiction. It was completely fabricated, and this was evidence of major and systematic corruption within the Avon and Somerset police, which in this particular case involved collusion in an armed attack against minors, against innocent civilians, as well as myself at the establishment. And the sweeping up. The finding of Power's report is what proved the corruption. But Chinwezi is relying on the report in the teeth of evidence the report. But anybody would need to know nothing really about the circumstances of the event I was complaining of in February 2008 to see that the report is utterly, completely corrupt. No evidence is provided, for instance, why the CCTV was not taken by PC Beer when she attended the scene initially. And the CCTV was everything just as it was in this case. And of course, we'll come in a moment to the CCTV surrounding the New Bridewell incident. So Chinwezi, who's a practiced CPS lawyer, is making it quite clear he's absolutely in cahoots, which of course and Judge Silber can distance himself from, because he's taken no part in. He said, "I'll leave it all to Mr. Independent Chinwezi to decide on what the grounds of my dismissing the application are." And Chinwezi, who himself is to become a judge, albeit in immigration court, it proves himself an utter conniver in the sort of child abuse and perjury and perverting justice, all of which is clear cut in Power's whitewash report. And as far as Chinwezi is concerned, presumably if he got the same report as me, he doesn't even know if Powers even exists, or Power even exists. There's no reference to Power on the record, and we don't even have his full name. It could have been drafted by Gilder himself, for all we know, and for all he knows. But we can know just from the face of it, the report is utter, vile, villainous, corrupt filth. The only reason that there's no evidence of what missile was thrown and that I was discredited because I said the missile was glass and not plastic, is because the debris was not collected by PC Beer, perverting justice in and of itself, and the CCTV showing what was thrown or giving some clear advantage or showing that whether it was swept up or not, because it's not clear in Power's report. Whether Power says who saw the debris? Did Power see did Beer see the debris or whatever? So it's all you need, all the evidence you need that Chinwezi is a child abuser, he's a perverter of justice, he's a liar, he's a crook, and he himself should be accountable for just on that basis alone. So lack of reasons. It is submitted the court gave full and adequate reasons for refusing the claimant's appeal as evidenced in the 5-page judgment of Judge Picton. Well, what reason was I arrested for? It's not if full reasons were given, and clearly why I was arrested is the key issue as to whether I was being kidnapped or lawfully arrested. What reasons does Judge Picton give? He fabricates without any evidence at all the assertion that I just wanted to provoke a situation to get arrested, apparently out of boredom, and apparently because the judge is inferring that I get off on being arrested and having strange men touching me, putting their hands on me and committing assaults. Even if I wanted them to, they're still committing an assault, certainly under Wood v DPP, because they're laying hands on me before they're even claiming to have arrested me. And of course, on the breach of peace issues, there's no establishing of what the breach of the peace law says, and of whether I met the criteria, if or when reference to the clear-cut violence or threatened violence threshold has been met in terms of breach of the peace. Refusal to summon witnesses. Two witnesses were in fact summoned by the court on behalf of the claimant. One was found to be present during the incident. Never mind the Ty Finlayson. Where is their reference to Stenner? Stenner needs to be called by the court, or the case needs to be stayed. That is the ruling of R.V. Haringey. Hopefully I would have found it to put up on the screen now. But obviously you cannot have a trial where one of the complainants who's in the very charge, whose name is mentioned in the charge, simply is not asked to attend court, and especially on the basis that Judge Picton gave, on the basis that I just wanted to accuse Of course, I wanted to accuse her, but on the basis I had evidence that along with the other witnesses, she was lying ahead of as to events. Indeed, she gave evidence in my favour because she, which Judge Picton didn't do, at least referred to the specific allegation of assault against Chapman, which was the essence of why I was visiting New Bridewell and the police station in the first place. In addition, the court heard from 8 police officers, and it was entitled to consider that the additional witnesses required by the claimant would not add anything further to the claimant's case. Well, that is not the issue. Is whether I have a fair trial under Article 6, which states that I'm entitled to, that the accused is entitled to ask any witnesses, all the witnesses who give evidence against them, which clearly included Stenner. She was the ringleader. She and Coombs started the whole thing off, as can be seen from the footage. Previous wrongful arrest, well, I've mentioned that. I'm not going to hold any huge store on that, except that if the police have falsely imprisoned me in recent times, I'm entitled to be more aggressive about potential further false imprisonments than I would be if they hadn't just falsely admitted to falsely imprisoning and apologised for falsely imprisoning and assaulting me, only a couple of years before. And we'll ignore the bit about CCTV. The CCTV of Chapman isn't going to be relevant until we've actually got reference to the allegation that I made that he was being investigated for assaulting me. Never mind that I could then prove the assault by way of the CCTV footage, bringing me off my arms. And of course, in any event, Chinwenzi, I'll just read it just for clarity, he doesn't even refer to what can be seen on the footage. The CCTV alluded to by the claimant at paras 53 to 54 of his grounds was that covering the earlier alleged assault committed on the claimant by security officer Mr. Chapman at the Bristol Magistrate Court. It is submitted that this relates to a totally separate incident and had no bearing on the behaviour of the claimant in the police station. So it had no bearing on, given that Chapman was under criminal investigation, given that I could have, I could prove the assault, or certainly prove to some extent the assault, had no bearing on whether or on the issue, even though the police themselves, or some of the police themselves, accepted what I was being upset about, or why I kept attending New Bridewell police station, was that the man investigated for criminal assault was barring my way to attend a hearing. Of course, which Chinwenzi at least refers to in passing, but Judge Picton doesn't refer to at all anywhere, in order for him to fabricate the claim that I'm there just to be arrested because he believes that not only do I enjoy being arrested, and presumably all the manhandling and injuries that involved from that, and of course by making such a ruling, he's encouraging, he's given permission for police officers to carry on doing the same. Don't worry, Mr. Gray enjoys it. Here's my ruling. I've established that Mr. Gray does enjoy it, but he's also avoiding, therefore, having to cover up why I was actually there, which was to do with the assault from Chapman, which even if he was acquitted of in the long run, or it was NFA'd by the hardly impartial Townsend, not only had some evidence to support, but was formally being investigated. The breach of the peace arrest, the court was entitled to find that the claimant's behaviour gave grounds for the police to apprehend that a breach of the peace was about to be committed due to the complainant's language and demeanour immediately prior to his arrest, including encouraging the police arrest him, abusing PC Stenner, refusing to leave the police station. So he relies on PC Stenner as the witness in this case. She never gave evidence, so he's got no material evidence from the person I was supposed to be calling an effing ugly bitch. From the actual horse's mouth, from her, that she even admitted that I was calling her that. And in any event, it is not that I was not arrested to prevent a breach of the peace. I was arrested because a breach of the peace had already occurred. Even Judge Picton, the vile, villainous liar that he is, even states that I was arrested to prevent, and that, although it was in brackets, it's clearly stated to prevent a breach of the peace, therefore logically a further breach of the peace, therefore a breach of the peace has to have already occurred for a further breach to have occurred. So Chinwenzi is lying about why I was actually arrested. He knows full well, because it's there even in the judgment itself and in the grounds given by the arresting officers. The officers and Judge Picton both clearly state in the clearest terms I was arrested to prevent a further breach of the peace, and therefore that a breach, they are stating a breach had already occurred. In what form the breach took is clearly implied by both the officers, which was that I squared up to Gilder, and that of course is covered by the perjury, which is the final part of Chidgey's judgment or decision, but it's actually a judgment because it's being made on behalf of Judge Silber as a form of judgment. But it's a complete bold-faced lie. I was not arrested to prevent a breach of the peace. I was arrested to prevent a further breach of the peace, therefore, because I had committed a breach of the peace. In terms of the law on arresting for a breach of the peace, incidentally, although it's not relevant because it wasn't why I was arrested, it has to be an imminent breach of the peace, and there may be some tenable argument generally about the alleged conduct that could have justified arresting to prevent an imminent breach of the peace. But that the arrest may be justified in law, but it's still as considered unlawful arrest. It gets immensely complicated in terms of the rulings about imminent arrest for imminent breach of the peace. But the imminent is crucial. It can't be just arrest and breach of the peace at some future period in time. Furthermore, there was contradictory evidence about whether I swore at or called Miss Stenner names at all, including the fact that Stenner was never called as a witness, and therefore the trial was illegal on that basis alone. Clearly, in any event, the officers referred to my squaring up to Gilder, which I never did, and that is clearly, by the officers' estimation, what they say either is the breach of the peace or the imminent breach of the peace, whichever fabrication you wish to choose, whether it's Chidgey's current fabrication or the fabrication from the officers or Judge Picton's fabrication, whichever one you choose. It's the key issue is surrounding the squaring up to Gilder, and that is a lie in and of itself, and which is why it's not covered by Martin Picton in his final judgment. He goes on a little bit more about R.V. Howe, and he doesn't mention, of course, Laporte, which includes R.V. Howe, but R.V. Howe all deals with the power of arrest to prevent a breach of the peace, but all of that is completely immaterial because the officers had claimed that I'd already committed a breach of the peace. Indeed, Chidgey is probably implicitly, or if not explicitly, admitting that there was no breach of the peace, prior to my arrest, and therefore that the reason given for my arrest, that to prevent a further breach of the peace, was not credible because I had not committed a breach of the peace, even by the officer's own version of events. Unless we talk about the squaring up, and of course that there may be some suggestion of violence if you loom towards somebody, which is one version of a squaring up, but that never happened, as I keep repeating. CCTV, the claimants of arrest, which of course covers the perjury, and that is really the essence of everything, because the fabrication covers whether or not there's been a breach of the peace, as well as the officers' other allegations against me and against their own and about their own conduct. To this, Chidgey states at paragraph 32, the court viewed the CCTV from New Bridewell police station and was satisfied it did not show any behaviour on the part of police that would necessitate the claimant acting in self-defence. Well, I mean, that's ludicrous, because the CCTV, first and foremost, proves that I didn't square up to Gilder. The squaring up to Gilder is the justification for the arrest given by the arresting officers, not only Coombs and Hamilton Smith, but Hamilton Smith and Coombs, notwithstanding Gilder doesn't allege that I squared up to him, but the squaring up is clearly the reason given by the arresting officers for the arrest, and the CCTV proves I didn't square up, and therefore the arrest was unlawful, that I hadn't committed a breach of the peace. So the perjury, which is hand in glove with the CCTV and surrounds the CCTV and the grounds of arrest and the self-defence, is dealt with in this way. The court was also satisfied that the evidence of PC Coombs and PC Gilder was truthful. As stated above, the disciplinary finding in relation to PC Gilder had no bearing on the factual findings. No perjury had been committed, and the judge had not colluded in any offence of perjury. For an offence of perjury to be permitted, it would have to be demonstrated by the claimant that the witnesses uttered statements that they knew to be false or did not believe to be true, contrary to Section 1 of the Perjury Act 1911. Given the claimant's admission that he had kicked PC Coombs and used threatening language, there is no evidence of perjury or of H.J. Picton's collusion in the offence of perjury. The interested party submits that the claimant's claims are spurious and wholly without merit and asks the court to refuse permission. Well, I mean, the issue of it would have to be demonstrated by the claimant that the witnesses uttered statements that they knew to be false or do not believe to be true. Well, clearly, I've stated, as I've stated here, in my grounds, that the perjury centred. Obviously, there were other less important bits, like whether or not I'd stood up as Coombstead and jabbed my finger at Stenner when I called her an effing ugly bitch. It can clearly be seen that although that my body is blocked, that they would have reacted in some way to that, and there would have been partially visible between them acting in that way. And then Coombs says I rose again, so he said I've done that, and I've sat down, and I've gone up and done that, and it's clearly not happened, as you can see from every single second as captured on CCTV of my exchanges with Coombs and Stenner. But the key issue is obviously what happens just after I've stood up, where I've been blocked by Coombs, and so again Chidgey is already colluding in the as Judge Martin Picton has done in the assault from Coombs by putting his hands on my chest and preventing my movement. That's false imprisonment and assault right there. And of course, I wasn't familiar as I am now with would-be DPP on assault, but the Chidgey should have been familiar with that. Then I move round, and then Gilder moves over to me and then puts his hand on me, and at no stage do I therefore square up to Gilder. The essence of the perjury allegation, as well as the false imprisonment, as well as the non-breach of the peace allegation, is all combined in the few moments between myself standing up and Coombs having to go through Coombs and then Gilder coming over to me, and me at no stage squaring up to Gilder, which was the basis of my arrest for breach of the peace. And indeed, the breach of the peace given by Gilder was that I had sworn at that officer, Stenner, and that I was being generally obnoxious. But of course, that is not the reason given by the officers themselves. They talk about the squaring up. The squaring up, therefore, was glaring perjury. And because I had squared up, the arrest was clearly illegal, and the breach of the peace had not occurred, and therefore, for that reason, the arrest was lawful. All of which is whitewashed by this liar, Chidgey. And of course, he's not. The idea is for him, not for him indeed, well, for him to respond in his defence, and then for the judge to assess whether that defence was as weighed against my claim, which had most merits, and he could only do that on the footage. If I say the footage shows that the officers are lying, the judge didn't lie about it because he didn't even mention what was in the footage. He just simply said the arrest was lawful. He said that the officers have powers and the arrest is lawful, and with no indication of what the footage shows or what the law says about breach of the peace. So I challenged them on the law of breach of the peace. By this time, I had obviously done some sort of research by saying no breach of the peace had been committed. And the only way Chidgey can get around that is by lying about even that the officers had claimed to have arrested me to prevent a breach of the peace, which in any event has to be to prevent an imminent breach of the peace, not just a breach of the peace. And in any event, they hadn't arrested me for breach of the peace. The officers themselves have said they've arrested me to prevent a further breach of the peace, even accepted by the judge. So clearly, the only way they've got to because Judge Silber has stated that he's said that my case is without merit on everything Chidgey says, he's supporting what Chidgey says, but Chidgey himself has not only lied about why I was arrested, but he's given no indication of what the footage actually shows. So the only way that anybody can assess whether or not, as you can do in this documentary, whether or not the statements are perjured is by detailing what's in the footage. Even the fact that Judge Picton didn't indicate what was in the footage, which can clearly be seen, you don't even have to see it in slow motion. It can clearly be seen that I do not square up to Gilder. So the basis of my arrest at that stage is an utter fabrication. I didn't even know Gilder was present. You can see that he is hidden, is lurking almost literally in the bushes. He's hiding behind the plant there on the left, and I couldn't possibly have seen him to square up with him, and I couldn't even have gone towards him because even if I knew he was there, because my way was blocked by Coombs putting his hand on my chest. And the only way that I could be accused of making a claim without merit is if if the judge had considered the breach of the peace in terms of Laporte v. Chief Constable of Gloucester, which isn't mentioned, of course, again, and of course the judge would have supposedly independently assessed that Chinwezi was lying about why the police alleged to have arrested me, which wasn't to prevent a breach of the peace, but prevent a further breach of the peace, the further being the key word, therefore stating I'd already committed a breach of the peace. The breach of the peace not having been committed by swearing and effing and blinding, because that does not amount to a breach of the peace. It has to be founded on violence or threat of violence. The only thing coming close to a threat of violence is the squaring up, which is of course why the police relied on that allegation, and that never happened. And of course, finally, even if often the position by these corrupt judges that I have to deal with are that it all happened in the heat of the moment. So if this great pile of rubbish comes out of officers' mouths, it's all because it was all in the heat of a moment, and they got facts a little in the wrong chronological order, and I only when I barged past Coombs, for instance, is different from when he arrested me, and all of that nonsense, because the perjury continued through 2 trials. Hamilton Smith was the investigating officer. As part of his investigation, he was investigating himself about whether he had committed perjury when he said that I squared up to Gilder. But he would have clearly had to have viewed the footage. Part of his investigation powers, even if you could possibly believe that it was legal for an officer to investigate himself in his own case, he clearly had access to the CCTV, as did the CPS. So the fact that they continue to maintain the grounds of arrest was because I'd squared up to Gilder, and of course how could things have happened in such a flurry of heated pandemonium that the one ground for arresting me was that even though I'm 8 feet away from Gilder and I'm physically being restrained from getting anywhere near him, although I'm not trying to approach him, I'm just trying to get out of the building where Gilder he's positioned himself by the doorways. So I would have to get towards him in order to move before the doorways, but in order to get to the doorway I have to get through Coombs. Coombs is illegally restraining me, falsely imprisoning and assaulting me, and then so I'm moving in the opposite direction from Gilder at the time I'm physically arrested, and Gilder comes, because I'm so far away from him, he comes 4 or 5 feet from where he's standing to put his hand on me himself to prevent me moving, and so unless these officers are there's no unless, they're just simply lying in order to build something up to justify an arrest. And in any event, according to Picton, he's must be lying to say that he knows without any evidence at all that in fact the real reason I was arrested was because for no earthly reason, ignoring the Chapman case, ignoring the investigation by David Townsend or whatever his name is, ignoring the previous other, the false imprisonment, the admitted false imprisonment in 2007, ignoring the 2008 missile in my face and cover up. Nothing to do with any of that, nothing to do with trying to expose any of that before an honest judge with who cares about the rule of law or with integrity. In the hope that if this case had gone before an independent judge who was properly applying the law, who cared about missiles being thrown at children, who cared about people being tortured, who cared about police officers who are supposed to be arresting people for perjury, not committing perjury themselves or perverting justice, then that's why then my arrest would have been a sacrifice, the sacrifice of my freedom and all the terror and the CS spraying in the first trial and everything else would have been worth it if it had finally gone before a judge with a smidgen of integrity who cared about the rule of law this country is famous for upholding. But instead we got this monster, this utter horrible villain who's simply one of many, many, many who are perched, still sitting there, still handing out judgment, still sitting in judgment of others, when they have the blood, my blood on their hands, and they are as guilty as sin in terms of collusion and misconduct in public office.